the greener globes.
I think your mic went off.
Who here wishes to possibly attend the state board meeting in Reading on the, what date, 6th and 7th of March, I believe.
6th and 7th of May.
6th and 7th of May.
Yes.
Oh, May, that's good. I thought she said March.
It's May. I think she might have said March, but
March is in San Diego.
March is in San Diego.
May, that's even better.
It's a Monday and Tuesday, first Monday and Tuesday in May.
I have interest.
I'm glad we got the date straightened out. I could see myself showing up and where's the meeting?
Clint will give you a tour either way.
You know,
Sure.
as long as I have my fishing rod with me. May's better though. So, Dan, you said you would like to go, Tim?
Yes, I think it's a place to be.
Okay. Anybody else?
Yeah, I'd like to go, but it's so far for me that I don't think I can make it.
Mark may like to go. I may like to go. So let's keep it open. If all three of us show up, you're going to have to ask State Board, as you pointed out, to amend their.
Yeah, and we'll still have to work through the reimbursements to see if we can get you reimbursed for travel expenses for that one, because
Right.
it is not a regional board meeting. So we'll
Understand.
make sure we'll get that. But I'm hearing interest from at least 2 board members. 4? There we go.
So you got up to 4, so I think you need to,
I will explore the option for a
Yeah.
joint meeting with State Board, and I'll get back to you and send you an update via email as soon as I can.
because I can see board members being able to maybe show up for one day, but not the other.
Absolutely. The current itinerary is very, very loose, but the idea is a tour on day 1 and the State Board meeting on day 2.
Oh, that's good. Very good. Thank you very much. Maybe we could, if necessary, maybe on the 5th, we could have one of our own board meeting, and that would then.
You know, it's entirely possible. I mean, I do want to stress, you know, that we can also hold workshops too. So just let me know what your pleasure is. We've got some time to work with. I think the agenda items, when we do process them, we have to process them a couple months out. So time isn't a huge luxury here, but we'll do our best.
Who coordinates this attendance by us? Does it go through your office then, Patrick?
It would go through our office, yes. Just let me know, and we'll work it through. But it's very important that we know whether there's 2 or more, because the requirements change quite dramatically then.
A couple board members might like to do some stream sampling.
Oh, absolutely.
Very good. With that said, we'll move back to agenda item 8, and I'll repeat what I said before. This is the time and place for hearing to consider revised waste discharge requirements for the Silver Ranch Biosolids land application area in Sacramento County. Is there anyone present who is contesting the proposed actions and wishes to present evidence or testimony on this matter? Now is your time to stand up.
Is anyone opposing the Silver Ranch WDRs?
Since there is no one present to contest this matter, the board will proceed with a brief staff presentation. Does council have any legal issues to discuss at this time?
There are no issues, Dr. Longley.
The hearing is now closed.
And I would say the board
No,
has.
we're not closed. We'll not begin the staff presentation.
There we go.
There we go.
That's more like it.
It is the board's preference if they want to hear this presentation or not. Since nobody is contesting the item, we can adopt or consider the WDRs based on the agenda materials provided. I think, how long is the presentation?
20 minutes, I think, 22
Yeah, so
minutes.
we actually have a fairly significant presentation planned, but there's nobody in opposition, so it is up to the board's pleasure whether it wants that presentation
And what
or
is your
not.
pleasure?
Well, I read through the materials and I always pay particular attention to the comment letters and responses, and I see that there's nobody here, so I would have a tendency to forego, and with apologies to staff and all their hard work, but to forego the presentation.
Yeah, I would move that we adopt the recommendation as presented without the presentation.
We do have the presentation, there's a lot of explanation to the slides, but we do have the slides. Okay. I hear the board's desire is that we forego the presentation and with our apologies and thanks for your preparation. Obviously, you prepared the board materials well because we have nobody up here contesting.
There was a great amount of effort put in by, you have Lonnie Andem and Scott Armstrong here, who worked a lot with the folks who were making comments in opposition to make sure that their concerns were met. I will say for the board's edification that two of the main concerns were the enforceability of the permit and drinking water monitoring. I think we were prepared to say in the presentation that the waste discharge requirements absolutely protect against nuisance conditions, and if nuisance complaints arise from the folks who were making the complaints, that we will go to the site, we will investigate, and we will enforce if there are nuisance conditions arising as a result of the disposal of biosolids. And with respect to the drinking water monitoring, I think that while this order does not require drinking water monitoring, the reason that this order does not require drinking water monitoring is because the agricultural acreage in that area is regulated under the Irrigated Lands Regulatory Program, and the orders that we just adopted this morning require drinking water monitoring. So the drinking
And-
water wells at the ag facilities will be monitored at the Cinder Grove facilities.
And why I feel comfortable going ahead and is I talked about both of those issues with the executive officer. Executive officer showed me where there was coverage. And on the odors bit, I think that we have an obligation there, but that's fully recognized by the executive officer and staff. And if there are odors off this site, and a couple of the letters talk about those odors, 2 or 3 letters talk about those odors, I have confidence that staff will react appropriately. So with that, any further comments?
I just made a motion, so I don't, and because it's an action item, I think.
Yeah.
You second?
Carmen moved. There are no late, there's
No late revisions.
No amendments. So Carmen moved, Raji seconded. Call the roll.
Ms. Ramirez,
Yes.
Ms. Brar,
Yes.
Mr. Bradford,
Yes.
Mr. Schneider, Dr. Markham,
Aye.
Ms. Kadara,
Yes.
Dr. Longley.
Yes,
Motion carries.
thank you very much.
Thank you. Sorry. See, to me, that's a superior accomplishment right there. Bam.
We're ready then to move on to agenda item 9. This is the time and place for a public hearing to consider an administrative civil liability order for Teng Vang of Shasta County. The designated parties to this proceeding are as follows. First, the board's prosecution team, and secondly, Teng Vang. All other participants are considered interested persons. The prosecution team has a combined total of 35 minutes for direct testimony, cross-examination, and a closing statement. Teng Vang has a combined total of 30 minutes for the same. Interested persons shall limit their comments to 3 minutes. A timer in all cases will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer I do. Thank you. At This time, evidence should be introduced on the following issue: whether the board should issue, reject, or modify the proposed administrative civil liability order. The order of this hearing is as follows. First is the testimony by the prosecution team, then testimony by Tang Vang, followed by cross-examination of the prosecution team, then cross-examination of Tang Vang. Next will be comments by interested persons. Then we'll move on to closing statement by Tang Vang, followed by a closing statement from the prosecution team. Please state your name, address, affiliation, and whether you have taken the oath before you testify. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranchi Rosardi, sitting over here at the staff table. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
At this time, I just wanted to note that the prosecution team did make a pre-hearing motion requesting permission to serve the complaint by publication, and the advisory team, after conferring with the board chair, who serves as the presiding officer, granted this request in ordered service by publication. This ruling, in addition to the prosecution's team motion and materials submitted in support, can be found in the record, specifically Exhibit 13, and it looks like Mr. Vang is present today and received notice.
Are there any procedural issues that the designated parties would like to raise?
Yes, Chairman Longley and the rest of the board. My name is Dan Kippen. I'm an attorney from the Office of Enforcement. I wanted to clarify, although I think it's a bit of a moot point, that the proof of publication that was submitted is in the record.
Thank you.
Thank you.
Are there any other procedural issues that designated parties would like to raise?
Not at this time.
Hearing none, we'll proceed with the prosecution testimony.
Good afternoon, Dr. Longley and members of the board. My name is Ryan Cornwall, and I'm a water resource control engineer with the Central Valley Water Board's Cannabis Regulatory and Enforcement Unit in the Reading office. I have taken the oath. We are here today to ask that you consider adopting an administrative civil liability order imposing liability against Mr. Tang Vang, the owner of the site at issue. During this presentation, I will be giving an overview of the site location, our history with the site, and the water quality impacts associated with the site. I will then discuss the steps staff have taken in an attempt to obtain compliance and restoration of the site, and the factors that were considered when calculating the proposed penalty. The site, Shasta County Assessor Parcel 041-300-006 and 041-300-033, is located on Duckett Creek Road, approximately 16 miles southwest of Redding, California, and directly adjacent to Duckett Creek. Duckett Creek is a tributary to North Fork Cottonwood Creek, which supports anadromous fish species. The North Fork Cottonwood Creek is tributary to Cottonwood Creek, which flows into the Sacramento River. Duckett Creek is considered a Class II watercourse, which indicates that it generally flows year-round and supports aquatic species and habitats. At the time of the inspection and issuance of the Cleanup and Abatement Order, or CAO, the site was owned by Mr. Tang Vang and Mr. William Claggett. Staff determined that Mr. Vang was the owner of APN 041-300-006 and responsible for the active cannabis cultivation operations at the site, which extended onto the adjacent parcel owned by Mr. Claggett. Since a portion of the site was owned by Mr. Claggett, the CAO also named him as a responsible party. Although Mr. Claggett does not reside on the property and was not aware of the cannabis cultivation activities that were occurring on his property, he has since complied with the requirements of the CAO, including implementation and initial monitoring of an approved restoration monitoring and mitigation plan for his parcel. Due to Mr. Cleggett's compliance, this administrative civil liability complaint only names Mr. Vang as the discharger, and the remainder of this presentation will only discuss the details and violations associated with Mr. Vang's parcel. This slide provides a summary of the chronological history of the Central Valley Water Board's involvement with the site. Observations made during the site inspection and subsequent enforcement actions will be covered in more detail later in the presentation. Initially, during the winter of 2015-2016, staff were reviewing Google Earth imagery and aerial photos taken during an overflight of the area and observed recent ground disturbance at the site, which appeared to be in support of cannabis cultivation. Staff determined that these activities occurred in close proximity to Duckett Creek and several of its tributaries and posed a threat to water quality. In June of 2016, a Department of Fish and Wildlife warrant obtained a search warrant which allowed staff to participate in a site inspection. During the inspection, staff documented ground disturbance and site operations that led to actual and threatened discharges to Duckett Creek and several of its tributaries. A draft cleanup and abatement order, or draft CAO, was issued in October 2016. In an effort to ensure delivery, staff issued a total of 3 copies of the draft CAO between October 2016 and February 2017. Cleanup and Abatement Order R5 2017-0701, or final CAO, was issued March 2017. The final CAO outlined the requirements for Mr. Vang to implement a restoration, monitoring, and mitigation plan, or RMMP. The RMMP is a plan prepared by the discharger that outlines the proposed remediation measures to restore and mitigate the site, as well as outlining subsequent monitoring efforts that would be performed to ensure the implemented measures are performing as intended. Mr. Vang failed to complete the requirements of the final CAO or otherwise communicate with staff, and a notice of violation was issued on July 2018. And an administrative civil liability complaint R5 2018-0528, or complaint, was issued November 2018. This figure shows the basic site layout observed during the June 2016 inspection. For orientation purposes, north is at the top of the page. During the inspection, staff documented 4 distinct areas of the site, including the base camp, which is shown here by the orange polygon. It's located on Duckett Road and directly adjacent to Duckett Creek. The northern cannabis cultivation area is shown by the purple hatch polygon, and the southern cannabis cultivation area is shown by the gold hatch polygon. Both the northern and southern cannabis cultivation areas were constructed on the hillsides above Duckett Creek and its tributaries. The upper access road, shown as light green dashed line, the mid-access road is shown as a darker green dash line, and the lower access road is shown as red dash line. The access roads were constructed on the hillsides above Duckett Creek and its tributaries and provided access throughout the site. The spring diversion is located towards the bottom right of the map and at the location of the blue star, and provided irrigation water for both the northern and southern cannabis cultivation areas. The northern and southern cannabis cultivation areas and the access road were constructed by clearing and grading and benching the steep hillside slopes. Watercourse crossings were created by the placement of fill material within the tributaries. The areas of disturbed soil and water crossings lacked erosion and sediment control measures. The following slides provide photo documentation and initial details related to the direct waste discharge and several threats of waste discharge that staff observed at the site. This aerial photo was taken looking northeast towards the site. The heavily treed areas indicate the tributaries that flow into Duckett Creek, located just below the bottom of the photo. The photo provides perspective of the steep slopes directly above Duckett Creek and its tributaries, where the clearing, grading, and benching occurred in the northern and southern cannabis cultivation areas and for construction of the access roads. The soil in the area is comprised of decomposed granitic material identified as show coarse sandy loam by the United States Department of Agriculture Web Soil Survey and has a high erosion hazard rating. The second photo was taken in the opposite direction, looking downhill towards the base camp, and shows the steep cut and fill slopes constructed directly above the tributaries of Duckett Creek. At the base camp, staff observed a tank that was being used to raise koi and provide irrigation water for the cannabis cultivation. Staff assumed that the koi provided additional nutrients to the irrigation water. The tank was being filled from a PVC pipeline that was routed from the spring diversion. This first photo shows a view of the discharge lines from the koi tank. The upper line is an overflow that was actively discharging waste from the koi tank directly into Duckett Creek, while the lower line provided irrigation water for cannabis cultivation. This second photo shows the upper discharge line from the koi tank actively discharging into Duckett Creek. Also at the base camp, staff documented disposal and storage of septage from pit toilets, which was located approximately 7.5 feet away from Duckett Creek. This photo shows imported potting soil stored at the base camp and located within 10 feet of Duckett Creek. This photo shows the southern cannabis cultivation area on a steep hillside above Duckett Creek. At both the southern and northern cannabis cultivation areas, staff noted disturbed soils created by clearing of trees, brush, and grading of the hillside to accommodate cannabis cultivation. The areas of disturbed soil lacked erosion and sediment control measures, creating conditions that threatened to discharge sediment into Duckett Creek and its tributaries. Staff noted an earthen fill dam that was constructed on one of the tributaries to Duckett Creek to create a pond. The dam fill material had previously failed, and the remaining fill material remains at risk of erosion and further discharge to the watercourse and Duckett Creek. This photo shows a view looking east and upstream at the dam failure and erosional gully that was created in the northern portion of the dam. The remainder of this presentation will focus on the subsequent progressive enforcement actions, including the administrative civil liability complaint and associated liability calculations. Based on the direct discharge and several threats of discharge observed during the site inspection, staff initially issued Mr. Vang a draft cleanup and abatement order, or draft CAO. Between October 2016 and February 2017, staff issued 3 copies of the draft CAO. All 3 copies of the draft CAO were sent to Mr. Vang at his 7313 Circle Parkway residence and included a 15-day comment period. Staff issued the draft via certified mail, standard mail, and personal service. Mr. Vang received the draft CAO as evident by the certified mail receipt on December 12, 2016, and Mr. Vang was successfully served the draft CAO via personal service on February 5th, 2017. After receiving no comments on the draft CAO issued to Mr. Vang, the final CAO was issued and received by Mr. Vang on March 13th, 2017, as evidenced by the certified mail return receipt. Due to Mr. Vang's failure to complete any of the required actions in the final CAO or otherwise communicate with staff, a notice of violation, or NOV, was issued on July 20th, 2018 to Mr. Vang's residence. The NOV was received by Mr. Vang on July 25th, 2018, as evidenced by the third certified mail return receipt. The NOV notified Mr. Vang that he was in violation of the final CAO due to failure to complete any of the required actions, and that monetary liabilities could be assessed against him due to noncompliance. The NOV requested Mr. Vang to submit all documentation required by the CAO no later than August 20th, 2018. After receiving the NOV, Mr. Vang emailed staff on August 28, 2018, stating that he had complied with Shasta County Code violations. The email included a copy of the October 24, 2017 Notice of Compliance that was provided by Shasta County. Staff responded to Mr. Vang's email on August 29th, explaining that county code violations, such as permitted property usage in buildings, are not related to the CAO issued by the Central Valley Water Board. The email response also notified Mr. Vang that the Central Valley Water Board staff had prioritized this case and may pursue additional enforcement actions due to noncompliance with the requirements of the CAO. In addition, the email response requested Mr. Vang confirm his correct mailing address and phone number that he could be reached. Since Mr. Vang's initial August 28th email, Mr. Vang has not responded or otherwise engaged with staff. On September 13th, 2018, staff received an email from Shasta County Building Code Inspections and Code Enforcement, indicating that the site had recently changed owners. Staff verified the site transferred ownership on August 13th, 2018, approximately 3 weeks after Mr. Vang received the notice of violation. On September 25th, 2018, staff issued a letter to Mr. Vang via certified mail stating that ownership transfer of the site does not in any way relieve him of his responsibilities to comply with the requirements of the CAO, nor prevent the Central Valley Water Board from pursuing additional enforcement actions due to noncompliance. The letter requested Mr. Vang provide documentation that the new owner was made aware of the noncompliance issues and existing enforcement actions associated with the property, including any agreements that were made regarding completion of the remediation and mitigation work required in the CAO. Additionally, the letter notified Mr. Vang that the Central Valley Water Board had still not received any response to the email correspondence on August 29, 2018 related to the NOV. The certified letter was unclaimed and staff has not received any response or documentation from Mr. Vang. Since Mr. Vang did not comply with the requirements of the cleanup and abatement order or subsequent notice of violation, the complaint was issued on November 13, 2018. Although Mr. Vang's failure to complete any of the required actions of the cleanup and abatement order resulted in multiple violations, the prosecution team is alleging only one violation based on Mr. Vang's failure to implement the restoration, monitoring, and mitigation plan by August 31st, 2017. The complaint package was sent to Mr. Vang by certified mail to his residence, where Mr. Vang had recently received the NOV and prior certified mailings in personal service. As this slide shows, there were 2 delivery attempts made on November 15th and November 30th, 2018. However, the package was not claimed. The prosecution team also emailed Mr. Vang notifying him that important documents were being delivered to his residence and asked that he confirm his current mailing address and phone number. The prosecution team confirmed Mr. Vang's residence was the most recent known address on Westlaw, which is an online legal research service. Due to the inability to serve Mr. Vang via certified mail, the prosecution team attempted service through a process server. The process server attempted to personally serve Mr. Vang at his residence on November 29th, November 30th, December 1st, December 2nd, and December 3rd. However, personal service was unsuccessful. The process server posted the complaint package at the front door after the final attempt on December 3rd. Due to the inability to serve Mr. Vang via certified mail or personal service, the prosecution team submitted pre-hearing motion number 1 on December 6th, 2018, requesting authorization from the Central Valley Water Board's advisory team to serve the complaint through publication. The advisory team granted the request on December 7th, 2018. The approved notice was then published in the Sacramento Bee once a week for 4 consecutive weeks on December 20th, December 27th, January 3rd, and January 10th. As previously stated, the prosecution team is alleging only one violation against Mr. Vang based on his failure to implement the restoration monitoring and mitigation plan by August 31st, 2017. Using August 31st, 2017 as a violation start date and the issuance of this complaint on November 13th, 2018 as the ending date, Mr. Vang has been in violation for a total of 440 days. However, the violation at issue qualifies for the alternative approach to penalty calculation under the enforcement policy as described in Attachment A of this complaint, utilizing the collapse of days. In this case, the prosecution team determined that the full collapse of days did not provide for a penalty that is reflective of the water quality impacts noted at the site, nor would it provide a sufficient deterrent. Therefore, the prosecution team elected to utilize a partial collapse of days, resulting in a total of 30 days of violation. Using the 30 days of violation, the calculated maximum and statutory minimum amounts are $150,000 and $3,000 respectively. However, the State Water Board's enforcement policy provides that the minimum civil liability imposed must be at least 10% higher than the economic benefit. Since the economic benefit plus 10% is higher than the statutory minimum, the minimum liability amount for this case is $4,547. The prosecution team, after following liability calculation procedures outlined in the State Water Board's enforcement policy, issued the complaint to Mr. Vang in the amount of $139,425. This table summarizes, this table on this slide summarizes the methods and factors that the prosecution team utilized when calculating the proposed liability based on the State Water Board's enforcement policy. The range for potential for harm is considered to be minor to major. By not implementing the required RMMP, the site continues to threaten to discharge waste to Duckett Creek and its tributaries and could potentially impact water quality and beneficial uses of receiving waters. Therefore, the prosecution team utilized a moderate potential for harm. The deviation from requirement, the range for deviation for requirement, again, is minor to major. Mr. Vang failed to implement the required RMMP, rendering the cleanup and abatement order ineffective in its essential function. Therefore, the prosecution team utilized a major deviation from this requirement. As stated previously, the prosecution team elected to utilize a partial collapse of days, resulting in a total of 30 days of violation. Culpability shall be assessed a multiplier between 0.5 and 1.5, with higher values used for intentional or negligent violations. Mr. Vang was aware of the violations noted at the site, had received the inspection report and documents from the Central Valley Water Board, and was given multiple opportunities to come into compliance. Since Mr. Vang failed to implement the required RMMP, despite having knowledge of the requirements, the prosecution team utilized a 1.3 factor for culpability. When there is a history of repeat violations, a minimum multiplier of 1.1 is to be used. Since Mr. Vang does not have a history of repeat violations with the Central Valley Water Board, the prosecution team utilized a 1.0 factor for history of violation, which does not affect the penalty. Cleanup and cooperation is defined as a multiplier between 0.75 and 1.5, with a higher multiplier when there is a lack of cooperation. Mr. Vang failed to comply with the requirements of the CAO and subsequent NOV and has not communicated with staff outside of his August 28th email. Therefore, the prosecution team utilized a 1.3 factor for cleanup and cooperation. Utilizing the factors listed on this page, the total base liability amount for this violation was calculated to be $139,425. The prosecution team considered Mr. Vang's ability to pay and continue in business. However, staff were limited to reviewing publicly available information regarding Mr. Vang's assets, as reflected in Table 1 of Attachment A of this complaint. Since Mr. Vang has not submitted any documentation related to the complaint or his inability to pay the total base liability amount, no adjustment was made under this factor. To summarize, Mr. Vang developed the site, including extending his operations onto the adjacent parcel owned by Mr. Claggett to cultivate cannabis, which resulted in actual and threatened discharges to Duckett Creek and its tributaries. Mr. Vang failed to complete any of the required actions of the cleanup and abatement order, resulting in multiple violations. However, the prosecution team is alleging only one violation based on failure to implement the restoration, monitoring, and mitigation plan. Mr. Vang was granted numerous opportunities to come into compliance and remediate the site. However, he chose not to complete the remediation activities required and has not otherwise communicated with staff outside of the email on August 28, 2018. For all of the reasons outlined, the prosecution team recommends that the board adopt an administrative civil liability order in the amount of $139,425 for Mr. Vang's failure to implement the required restoration, monitoring, and mitigation plan. The prosecution team requests that this presentation and all evidence exhibits be included as part of the record for this matter. Thank you.
Questions for the prosecution team? Thank you. At this point in time, we're ready to receive testimony by Teng Vang, Mr. Teng Vang.
My name is Tang Vang, and I took the oath before I'm at the podium. And I just want to tell my story, like how everything happened. When I bought the property in May of 2015, a lot of the gradings on the hillside, that stuff already had occurred, and I had no idea that the grading that was done on the hillside were non-permitted, and I leased out the property in 2016 to an individual, which resulted in complaints, and complaints were filed, and I had requested the individual stop what he was doing, and I worked with the county officials to correct the violations. I thought that because the county and the water board, they're government agencies, they might have shared information, and I thought that if I satisfy the county needs, whatever the violations were, then that would transfer over to the water board, which I was completely wrong about that. I started cleanup at September 2016, and I continued to April of 2017. So I tore apart the koi pond, removed the spring water collector, anything that would be considered hazardous, like as far as chemical, I cleaned up everything. Anything detergent, like such as soap, Roundup. I picked up all the trash, covered up the soil, removed the irrigation piping, and as Mr. Cornwell stated, the county sent me a letter of compliance in October 24th of 2017. So I was like I mentioned before, I was under this assumption that that matter met the requirement, and one of the reports that I received was about the hillside grading and how when I was reading the report, it's missing. It had some dates that were missing, and I just wanted to illustrate. So it says the 200-acre site appears to have been largely undeveloped prior to 2011, and the historical Google Earth satellite image from 2004, 5, 6, 2009 and 2010 indicates natural hillside with no grading access road present, subsequent clearing of trees, and grading is visible in 2011 Google Earth imagery. And since 2011, the site appears relatively unchanged with numerous graded access roads and clearing hillsides. Then from 2011, it skipped to June 2016 to mention that participated in overflight area of the notice and of the area and noted additional hillside clearing and the presence of cannabis. So as far as the hillside, the grading or the carving of the hillside, nothing was mentioned about 2011 to 2012, 2013 or 14. During that time, I have not occupied the property, and county records show that there was a large grading project that was done in 2011 to 2012. So when I bought the property, my agent told me that all those were existing roads, and he told me that there were existing roads. You know, you can drive up them or whatnot. And as I was stupid because I didn't do my research, and I didn't know where the boundary lines of the property was. I relied on an agent to tell me, okay, this is where the property is. You know, so so as far as the hillside carving, it's as I talked to the county before, they mentioned that, okay, I told them stories. They're saying, okay, even though you didn't do it, you're on the hook for it. So I was like, okay, well, how is that fair if I didn't do any carving on the hillside? So I guess that's how the rules are, and it can't be changed. As all the other stuff that occurred, I've been able to clean up, but all the hillside carving, that part I didn't do, and that's something I can't change. They say ignorance breeds stupidity, and I was being ignorant and stupid. That's it. I mean, I don't have much.
Members of the board, any member of the board have questions, Mr. Vang?
Mr. Vang, so you leased your property out?
Yes.
Okay, and when you bought the property, you said the hillside already had
There was
the roads.
already, all the grading on the hillside was already there prior to my arrival. And the report from the water board, it doesn't talk about 2011, it doesn't talk about from 2011 to 2012 to 2013 to 2014. It only mentions from when I occupied the property. So the previous owner would know much more than I do.
So when you bought the property, usually they stake out your property before you purchase it, so that wasn't done for your parcel?
There was a metal spike, a marker, but that's what my agent told me.
Okay, thank you.
Any further questions?
Yeah, I'd like to ask you, our staff made an attempt to see you personally. What happened? Are you aware that they tried to get a hold of you?
Well, I was, but I was stupid. And it might sound funny, but I was scared.
Any further questions?
Yeah,
Yeah, go ahead.
Mr. Vane, you mentioned that your agent didn't provided you with information, but you didn't have any knowledge of what was not correct or whatever. So when the staff came out to you and you didn't respond, do you not realize now that had you responded, some of those questions that you're raising now could have been addressed with the staff? And, I appreciate your honesty before the board today. That's half the battle, admitting the issue, but before us is the fact that we have an order here to cease and desist, and all that time there was no response. So prior to you owning the property, there was someone else there responsible. I don't think our staff is holding you to that, but when they communicated with you, they didn't get a response. And there was that opportunity in between all that time, 2016, to where there could have been an opportunity for you to share your honesty and what you didn't know, but now you're in this situation. And it's an unfortunate thing, but we do appreciate you coming today to represent your group and provide your response.
Can I say something?
Sure.
Because if the staff has the Google images from 2006 to 2016, they would have seen when that hillside grading was done,
When did you buy the property, Mr.?
2015.
Well, those issues that you saw that were present that you state were present in the earlier Google images could have been corrected by you upon taking control of the property, and that would have avoided a lot of these issues. So in my mind, the fact that that was there prior really is not very convincing, because if you had worked with staff, all of this you probably wouldn't be here today. Any further questions or comments by board members?
I have a comment.
Yes, I have a question. I'm sorry. Has staff been out to the site to verify that he has in fact cleaned up the surface activities that he described since the order?
We've been working with the northern property owner, William Claggett, and through compliance inspection scheduled with him and his consultant, we've traveled to the site. However, we haven't done another inspection on the APN at issue right now.
When is the last time you've been out there?
We were out there maybe end of December to do a compliance inspection on the northern parcel with Mr. Claggett's representative. And we did travel through the site. However, we were only able to observe it from the access road. And so the only thing we were able to observe was directly from the access road and not up on the hillsides or any of the other areas of the site.
Bob, I think you had a comment.
Yeah, I'm glad you came today. I appreciate that. And I get concerned when people use the term that I was stupid, because I don't think you're stupid by any stretch of the imagination. But I do understand scared, actually. That's probably a pretty real word in this case. You might say you made a bad mistake, or you really messed up, and that's true, I think. But I would ask you to not characterize yourself as being stupid. I think that's denigrating and not necessary. I will ask staff after a bit, just given what they've heard, and I'm pretty supportive of staff. They did everything they possibly could to reach out to you. But is there, the staff will make a recommendation to us about this, they're also having heard the testimony, and we'll see where we go from there. So thank you very much for being here today.
I have, I don't know if this helps, but I have photos of the corrections that I've made it's just on paper. I didn't have any idea that you guys have computers that we can just do the presentation.
Quite possibly you could share those with staff. Yes, go ahead.
No, I was gonna say that, I was gonna ask this, so this last time you went, you couldn't stop on the property, right? Because you weren't there for that, you were for the different property. But if the changes, or if the changes that he says he made had not been corrected, do you think you could have seen them from the road that you were traveling on?
It's difficult to tell. Most of the base camp area is below the main access road, and it's a pretty heavily treed area. And so it'd be difficult to answer that question, whether or not we would have been able to see them or not. And like you mentioned, we were only allowed onto the William Claggett parcel, so we pretty much went through there and onto his parcel without making observations on Mr. Vang's parcel.
Okay, so if he's testifying that he fixed these things, do you have any information to contradict what he's saying?
No, we don't have any information to contradict that.
I would suggest, this is Patrick Palupa, Executive Officer, member of the advisory team. I would suggest that if Mr. Vang has photographs of what the site looks like now and wishes to submit them into evidence, it would be a late evidentiary submittal. I suggest as a first matter, we would take a short recess at the conclusion of Mr. Vang's testimony to allow Mr. Vang to present that evidence to the board's prosecution team for their consideration, and then we could have a discussion about whether that matter would be admitted into the record or not.
I'd like to hear from the prosecution team on that.
Yeah, I just wanted to provide one clarification to the answer to Ms. Ramirez, if that's okay, regarding the,
Go ahead,
the work
go ahead.
that he's done. I would like to clarify that the soils that were stored down by Duckett Creek, as well as the koi tank and the irrigation system, are one portion of the issues that we noted on site. Had those been remediated, that would be one part of what the restoration monitoring and mitigation plan would be covering. The other areas of the site, mainly the access roads and the additional watercourse crossings, if those have not been remediated, those would still be outstanding issues and threats to water quality.
But so you mentioned two different groups of issues or problems on the site. And as I understand, you were on the access road, but were you able to observe any of the road crossings that needed to be addressed, or were you able to observe the pile of dirt and the other structure that you mentioned?
We were able to observe the crossings that were located on Mr. Claggett's parcel, since that's what we were there to inspect. The crossings located on Mr. Vang's parcel were, we would have had to go over a hillside to go view those. And then as far as the structures and the stockpile of soil, we didn't make any notes or documentation while we were out there, so we didn't directly observe whether or not those were still existing.
Okay, and I'd asked a question earlier about Mr. Vang has some pictures with him that he claims address some of these corrective measures that he has made by his statement. What is the position of the prosecution team of taking these as evidence?
Prosecution team endorses the executive officer's suggestion of taking a break to see what exactly we're talking about.
Good. We will do that then, and be advised that that once we come back and discuss that issue, that Mr. Vang still has time to cross-examine the prosecution team. Do you understand by cross-examine, that means that you can ask questions of the prosecution team? You really can't make statements, but you can ask questions to clarify issues. And then they will have the same opportunity to ask questions of you.
Okay.
Do you understand the process, Mr. Vang?
Yeah,
Very good. And then we'll proceed on from that point. At that point, when we come back into session, quarter after 2, how much time do you think you need?
Could we get a representation of the number of pictures?
Let's see,
Is it less than 20?
probably less than 20.
Then 10 minutes should be fine.
Sure.
And I would
so-
just ask, while we're on the subject, do you also have copies for the advisory team, or should we pass those on to the advisory team after we're done reviewing them?
I just have only 1 copy. Yeah.
So let's be back here at 2:30.
Can I ask one more question before we leave? You said you transferred this property to another owner at this point?
The owner that currently is now, he was the note holder of the property because I was making payments to him.
Okay, so is access to your prior parcel available to staff, or does that require another hoop or two to jump through?
Yeah, after we were made aware that the property was sold, we were in contact with the subsequent property owner who, when he was made aware of the issues with the property, he immediately put it up for sale. And while it was up for sale, we were working with potential buyers. And so the current owner of the property is aware of the issues. We've met with him. He's in the process of putting together a remediation plan, and we're trying to coordinate with him. He's out of town to meet with him on site to do a site inspection and observe the current conditions of the property.
Okay, thank you.
Thank you. So-
Willing
so-
to be the new owners are willing to be in compliance and meet.
Very much so. Yeah,
We're in recess till 2:30.
So let me see if we can get copies made. Is that feasible? Or do we just have one set?
Some for the advisory team as well?
set up on my email account.
Only one small complaint, and that is, okay, so you have him as John Constantino. John used to sit here.
Oh, yeah.
Yes. Mark sits here now.
We will correct that.
Okay.
There's a few Pamela first.
Oh, so you can see when my button's on? Is that how that
Yeah.
works? Oh, yeah.
Or actually, I'll pass them out.
Yeah,
Just-
makes more sense.
Back in session. I'd like to hear comments from the prosecution team regarding the photos.
Although it is a late submittal, we do not object. We think they're fine to be put into the record.
Very good. We'll accept them into the record, and our copies being made for the board. You got copies.
They're on top of it.
Oh, they're fast. Those guys get things done. Okay. Mr. Vang, if you would like to at this time, if you have any questions for the prosecution team, they're sitting up here.
Yes, sir.
Go ahead and ask your questions.
Yes, sir. I want to address or ask the prosecution team, as far as the report, why was from 2011 to 2015 in the report, why was that part missing? Because that could have shed some light on when the grading was done.
So on page 2 of the inspection report, which is an attachment to the complaint, on the background section, we do state that according to dates identified in Google Earth historical imagery, initial grading and road construction appears to have been conducted between July 2011 and August 2012. So we did do historical Google Earth research imagery and did include that reference in the report.
Yes, sir. 2011, 2012, but I was also asking about 2013, 14, and 15. Why was that part missing?
Being that it's not currently in the inspection report, I wouldn't be able to adequately say why it's not in there, other than the fact that we did do overflights and noticed the 2015 imagery is when we first saw the grading, or the hillside clearing.
Because I believe that if you would have had 2013 and 14, you would have seen the grading prior to my occupation. Sorry.
Just ask questions.
Okay.
You'll have a chance to make a statement later.
Okay.
You have any further questions?
Yes, sir.
Go ahead.
And if I could pause for 1 second, when you reference page 2 of the Vang Claggett inspection report, I just want to let the board know with respect to your package, it would be numbered page 76 at the very bottom. The Bates numbering would be page 2 of the inspection report.
And then if I can provide a little bit more clarification as well to Mr. Vang's question. There doesn't appear to be Google Earth imagery in the years of 2014. So we do include as an evidence exhibit Google Earth historical imagery of August 2013, and then it skips to August 2015.
And just as an aside at this point, I'd like to thank Corinne tremendously, because if you notice, we were able to refer for the first time. We're able to refer to pages and go to those pages. She's learned the technology. Thank you. And I appreciate being able to go to page 76 and see what's here. So go ahead, please. I'm sorry, I get that in at this point.
One of my other questions is, under what law is it that when somebody can be blamed for somebody else's doing?
Given that that's a legal question.
Could you identify yourself for the record?
Sure. Dan Kippen, attorney from the Office of Enforcement. I can answer that question. I'm just not sure if that's appropriate for this aspect of the proceeding.
I think it might help elucidate the board as to the prosecution team's position as to the laws that were allegedly violated, or the legal theory under which Mr. Vang is being prosecuted here.
Sure. So at this point, I will belatedly raise my hand and say I do, because I did not anticipate giving testimony previously, so I did not raise my hand, so I do so
I
now.
noticed you didn't. Okay. So do you say that what you say is the truth? If so, answer I do.
I do. The CAO, which unfortunately I do not have the Bates numbering available, but it was attachment B to the complaint. On pages 8 through 10, list out the legal authorities.
Page 59 in the packet.
Thank you, Executive Officer. Specifically, paragraph 10 refers to Water Code Section 13304, and there are other aspects that are relevant, but the short answer is that the Water Code Section 13304, subsection A, provides that, let me find the right part here. The key language is caused or permits. And as the owner of the property, at the time that the inspection occurred, he was either causing or permitting the discharges or the threats of discharges. And if that answers the question, I'll leave it at that. And
Well, let me ask you a question. Is the purchaser of the property, unless it's otherwise stated in the sales contract, responsible for conditions of that property?
essentially, you are responsible for the condition of your property at all times, whether you cause the conditions on the property or a predecessor or frankly a trespasser. It's just from a practical matter because it becomes very difficult from an enforcement perspective to try to track down who may have historically caused something. Now, of course, a property owner is free to investigate who caused a condition on their property and pursue them civilly, but the water code allows us to just point at the owner of the property as being responsible.
So what I hear you saying is the recourse, if there is damage to that property, the recourse of the owner of that property, the new owner, is a civil action against the preceding owner. Is that correct?
That's correct.
Thank you.
Dr. Longley, if I could expand on that just a little bit. This is Clint Snyder, Assistant Executive Officer.
I think we might be getting a little bit beyond the scope
I know,
of the
yeah.
cross-examination.
We are. So, do you have any further questions?
No, sir.
Okay, then at this point in time, going through this, does the prosecution team have any questions of Mr. Vang?
Just a few. I'm going to reposition the microphone so I can sort of look at you. You previously resided at the 7313 Circle Parkway address?
Yes, sir.
Is that your current address?
Yes, sir.
And you're aware that multiple documents were sent to that address regarding this matter?
Yes, sir.
And those documents included draft cleanup and abatement order, notice of violation, and the complaint that's at issue today, correct?
Yes, sir.
And did you receive those documents?
No.
Did you?
I was aware that documents were being sent out, but I didn't receive anything.
How were you aware that those documents were being sent out?
I had an email that informed me that, okay, documents is getting sent out.
And how did you become aware of today's proceeding?
It was from the newspaper. I have a friend that noticed it and pointed it out.
Thank you. Nothing further.
Thank you. Guess I'd like Patrick, ask you a question. We have these photos. I'm tempted to let Mr. Vang go through those photos and point out anything he desires to us. Is that proper?
I mean, I think it would be totally appropriate. The pictures have been admitted into the record. I think
Sure.
The prosecution team, certainly as part of their closing, could also opine on what those pictures show or on what those pictures do not show with respect to the condition of the site. My own personal kind of quick assessment of the photographs are that they are consistent with the prosecution team's case that while much of the infrastructure was removed, some of the slopes and the slope stability issues that were present at the property before Mr. Vang bought the property and while he owned the property are not shown as being remediated by those photos. But I can certainly let the prosecution team, verify that, and Mr. Vang is free to say what he will about them.
Okay, I don't believe there's any other interested persons who want to testify. Are there any interested persons in the audience? Seeing none, then. Mr. Vang, next would be your closing statement, and as part of your closing statement, you can begin by going through these photos.
Before we get to his closing statement, can I ask a question?
Yes, ma'am.
Mr. Vang, we have kind of a hard consideration that we have to make.
Okay.
And this is not a normal type of question, but I'd like to know what you think is a fair outcome based on the effort that the board's put in, based on your defense. What do you think is a fair outcome?
Well, like I asked the gentleman here, under what law can we blame somebody for an action of another? So when I was cooperating with the county, I was doing everything I can to mediate all the violations, and the only thing that I couldn't do was the hillside grading, and because that wasn't something I did, and it was a large scale grading that was done prior to my arrival of the property. So when I talked to the county, they told me that it's going to cost you $50,000-$60,000 to get an engineer, surveyor come out with a contingency plan. That was overwhelming. I was like, I couldn't do it. So it was very frustrating. I wish I could. And I don't think it's fair to be blamed for something that I didn't do, or the current owner right here, which is, his name is James Gray, because when I bought the property, it was from an individual named Robert F. Scott.
So I understand, and I think that we're all sympathetic to what you're telling us, but I'm trying to figure out, I know that you don't think you should be responsible. The law doesn't say that. The law says that you are responsible. So understanding that you are responsible, that you did kind of dodge service, you may have been complicit in some things, although maybe you didn't do it. Balancing everything out, what do you think is a fair outcome?
I really don't know.
Okay, do you think 150,000 is a fair outcome?
Negative, ma'am.
Okay, so then what do you think is a fair outcome? Because this is what's presented to us,
Yes,
right?
ma'am.
So this is your
Yes, ma'am.
chance to tell us what you think, given that you're not completely free of blame, but you
Right.
may not have done everything. I'm not saying that you did or you didn't. I'm just asking
Yes, ma'am.
for a number, please.
Like I mentioned before, it might sound stupid, but I'll throw out a number, 10,000.
Okay, all right. Well, I appreciate you trying to give us your opinion on where you think this falls.
Yes, ma'am.
All right.
So if you want to proceed, at this point, give us your closing statement, but you can start that out if you so desire. It's up to you. If you want to go through these pictures that we have.
Yes, sir. I need a copy.
He needs a copy back.
Yeah.
He has a copy now.
Okay, thank you. So, starting with the ones that says irrigation pipes, kind of handwritten.
That's going to be probably the last one in your packets, but it's because I went through the pictures already.
It's in here, and I think it differs where you are, but yeah, second to the last.
Okay. Irrigation pipes. These were the irrigation pipes that were coming from the spring, the spring. So all the pipes were taken down and put in this little storage bin right here. So nothing's there collecting water from the spring.
Okay.
Next one, there's a picture of some vegetations, and that was, this location right here was where the spring was, with the little totes that were collecting the water, and it's been taken out. I've got multiple pictures of where the springs are. There's actually 4 images of where the spring was, or that's where it is, the spring. So there's nothing there collecting water. Next one is from the side of the cabin, and there used to be like empty bottles, you know, cans. So I cleared up everything around the building. I just took a photo of this right here. It says clean up, trash removes. The next image is the one with the ladder, and that wood right there was the koi pond. So it's all been torn down and stacked up nice, neat. The image with the, there's a little bench seat right there. This was on where the side of the koi pond was, but the camera's not directly pointing towards the koi pond. It's pointed towards the side of the building just to show that there's no trash over there. And there's an image right here that says koi pond. This was where the koi pond was, and it's been removed. Next image, it's got there's a little doghouse right there, and that's where the pit toilet was, and that's been torn down and taken care of also. So it's no longer there. Here's an image right here. There's of the soil, and it's been covered up with a tarp, and you got cinder blocks keeping the tarp down so that the wind doesn't blow it away. And I think that's it as far as the images.
Do you have any further statements to state?
No, sir. No more statements.
Thank you very much. I have one last question for you.
Yes, sir.
How many crops were you able to harvest from this site? How many years?
I was just there. I was there. I bought it in May of 2015. So I have a regular job. I'm not out there, so I just lease it to people.
But how many crops did they get off of it while you owned it?
These guys didn't get anything because everything was chopped down. So,
But initially, they got, we saw some pictures. They got some crops off initially, didn't they? 1 or 2, 3, 4 years?
no, because I was only there from 2015 to, and then,
Okay.
yes.
Thank you. This time, we'll take a closing statement by the prosecution team.
At this time, we'd request a short break to make some possible revisions.
Okay, 10 minutes enough?
That'd be fine.
We'll be back at 3 o'clock then.
Hang on a minute. I mean, I am thinking of a few revisions, and let me give them to you so you'll have them.
Sure,
but,
sure.
You know, I mean, the basic thing is, I think communications were ignored, and that's not, you know, that's not a good thing, and that's not our fault as an agency. I think our staff have done an exemplary job of trying to ensure that Mr. Tang has the information thing. But he did clean up some of the stuff, and I appreciate that, and he is here today. And so I was kind of thinking about the culpability as being 1.1 instead of 1.3, and I was also thinking about cleanup and cooperation being 1.1 instead of 1.3, but that's just my thoughts, and in your adjustments, you may consider that or not. Thank you.
And for board's information, I've been approached by attorneys for the advisory team suggesting that we go into executive session following the statements by the prosecution team.
And I would sort of prefer not to do that unless there's an overriding reason why we need to. Is there something that's particularly important or that we shouldn't be doing, or?
Not at the current
It's
juncture.
just an option.
Yeah, it is just as an option.
Yeah.
If we want to debate the merits of the enforcement calculation. Generally, it's advisable to go into executive session, particularly when you have board members that may have questions about how to work that particular calculation. Bailey is certainly well equipped to answer the questions with respect to the use of the enforcement calculator. And then my suggestion would always be that when we debate whether it's a 1.1 or a 1.3, that we come in and have that debate fully in front of the public. But if you have any concerns about how the enforcement calculator would be deployed, we can answer
All right,
those
and
in
that
closed
was my
session.
point, is I think that sort of discussion, we've always made a public discussion,
Yes,
and I think that's
yes.
part of the value of this board. So-
Right.
I think it serves.
I would
yeah.
rather, for something that goes way back in my history, I prefer to do it in public. But for the reasons that Patrick suggested, I'll ask the question again when it gets to that point in time. At this point in time, we'll be back at 3 o'clock and let you folks get your discussion done.
Dr. Longley, this is Clint Snyder,
Yes,
Assistant
sir.
Executive Officer. You provided us 10 minutes, which I certainly appreciate. We'll need some time to upload the enforcement calculator in order to.
I expect you to be back here as soon as you can. Go do it right now, okay?
Thank you, sir.
Yes, sir. Yeah. Rather than sitting here debating time limits, go do it. Maybe space it another minute. Yeah.
Your experience, you know what got one new board member.
Yeah.
Like my first.
He did say that the new owner who held the note is going to comply with restoration rating this also.
Yeah, my own opinion, I think something on the order of 35,000 is appropriate. Well, that's the cost of a new car.
Yeah. Small.
Small new car.
Take more time with this than the whole ILRP. The other way around.
These sometimes become the stickiest ones around.
It's a life changer for him.
Are we going into executive session?
No, and I, Okay, are we ready to go?
If the prosecution team is, we are ready to go.
I understand
Yes.
that a
Yes,
new
sir.
document is being uploaded as we speak, and as soon as it's up, we are ready. And it appears it's on the system now.
What? Yeah, I'll get up there.
Oh, sorry. I'll just sit over there.
Dr. Longley, members of the board, again, my name is Clint Snyder, Assistant Executive Officer with the Central Valley Water Board. For the record, the prosecution team would like to note a couple of facts. First, there's been a significant amount of time and energy poured into this case for the last 3 years. The prosecution team is not charging Mr. Vang for grading work or any discharges to waters of the state associated with that grading work as part of this case. Moreover, the prosecution team is only charging Mr. Vang with the failure to submit and implement restoration, mitigation, and monitoring report. We made repeated attempts up to and including posting in the newspaper at significant time and expense to the board, which detracted or diverted our staff from addressing other casework. It was only when we issued the ACL and posted in the newspaper that Mr. Vang came forward. While we appreciate his being here today, his failure to comply has not only resulted in likely continued or threatened discharges of waste, but he has potentially profited from the lease and sale of the property and passed the cleanup obligations onto other parties, that being the new owner. However, in light of the conversation today, Mr. Vang's presence and his late submittal of evidence, the prosecution team would like to revise our recommendation. This is up here. Can you guys see that? Okay, let's make sure it's there. We would like to consider Member Schneider's recommendation of reducing the culpability to 1.1, cleanup and cooperation to 1.1, incorporating those factors into the enforcement policy, and then the penalty calculator results in a penalty of $99,825. That said, the prosecution team is certainly open and willing to consider any further advice or considerations from the board. Thank you.
It's time for board members to ask questions if you have them.
I appreciate staff making these adjustments. I also appreciate Board Member Snyder's recommendation. I think that although Mr. Vang, he expressed his honesty. He shared that with us today. The violations are definitely something that needs to be addressed, and his defense was that prior to him owning the property, the previous property owners had done these things. But I know the laws for real estate is there's disclosure. So somewhere in the process, some information had to go out to what was at the property. And I think that this is a reasonable fee or penalty for Mr. Vane to pay, and I'm okay with the recommendation at this time.
Any further questions or comments by board members?
And just to clarify, that's the revised recommendation, which would result in an ACL of $99,825.
Any further comment?
Yes, I got one. I'd like to have an explanation by staff, the prosecution, about the 30 days of violation. How was that calculated, and is there any flexibility there?
Yeah, this is Griffin Perea, Senior Engineering Geologist with the Reading Office, and I've taken the oath. In the enforcement policy, when the prosecution team can make an express finding that an economic benefit was not able to be measured on a daily basis for the violations, that we can reduce the days based on a factor of 1 day for every 30 days of violation. And following the methodology in the 2010 enforcement policy, that's what we utilize to reduce the number of days to 30 days.
And if I could, I would suggest that the question with respect to the flexibility be answered by advisory council, not prosecution team council.
This is Bailey Tatapu with the advisory team. Griffin is correct as he just testified about the enforcement policy and the ability of the board to collapse the number of days of violation pursuant to that policy. And I can walk you through, if you'd like me to, and how that collapse works. Here the prosecution team is recommending a partial collapse. So we're under the enforcement policy, the total number of days would actually collapse to 20 based on the issues at the site. The prosecution team had recommended a collapse of 30.
So the answer to my question is there is some flexibility on that number, the 30 days.
Yes.
Because that's what I might suggest to my fellow board members. I'm inclined to stay with the original calculations in step 4, but then maybe change the days.
I also have a question. I know on when we do previous ACLs, we always look at the ability to pay. Was that looked at here?
Yes, we did analyze Griffin Perea. We did analyze the ability to pay. We were restricted to publicly available information on asset ownership, which is outlined in Attachment A, Table 1 to the complaint. And I believe the only asset we were able to find was ownership of the parcel. That's the matter of this record. Sorry, I've been corrected. There's 2 properties, one being the parcel, one being a residence. And so we did utilize that publicly available information. However, due to the failure to submit any additional financial information, we ultimately didn't make an adjustment under that factor.
So if you would have had previously communicated with Mr. Bang, that possibly could, obviously would have played into the scenario today, correct?
Yeah. If we had received more information on the ability to pay or inability to pay and documentation related to that, then it could have resulted in an adjustment under that factor.
Thank you.
I had my microphone on because I liked Member Markham's analysis, and so if I would be inclined to support that.
So by that you mean a reduction in the number of days?
Yes, to the statutory minimum, which I believe was 20.
I'll agree with that.
The minimum that I had said, if you're going through the procedure set forth in the enforcement policy for collapsing the days, it would actually calculate out to 20. But the statutory minimum is separate from that, and I believe that's...
So I used the wrong terminology. I meant to say, based on the policy that you cited. Sorry.
Okay, no worries, thanks.
And I
So-
would vote against that particular motion.
We're not to a motion yet, I don't think. We're just having a little discussion here.
If it were to be made a motion.
Can you explain, Member Schneider?
Yeah, I think staff's judgment's important here in this part. And this, The other ones, like culpability and cleanup and cooperation, he's done some cleanup. I was willing to adjust that. He is here today. I was willing to adjust that. But I trust staff's professional judgment in picking this maximum day of violation reduction. And a lot of this has to do, this is a violation. It's a violation that's occurred on a cannabis grow, and we're now responsible for regulating these grows, and I work with Clint closely on the development of a lot of the early phases of the cannabis regulatory program, and I think that their recommendations and their professional judgment is to be respected in this case.
And I have to concur with Mr. Schneider. This is really about the first of many of these that we're going to see. And you got to remember that you're setting a precedence today.
And I recognize that, and I guess maybe I'm hypersensitive, but I want to make sure that we don't end up trying to find the right number at the end and then adjusting the numbers to get there. You know, if there's, I said it earlier, and I mean, the writing office is exactly, you know, what I have in mind when I say, you know, complete trust in the information that they bring us. I trust their judgment. And so adjusting the days of collapsing, to me, doesn't impede on their judgment. This, you know, we sit up here as appointees, you know, by the governor to try to make the right choice. And so I'm not trying to undercut their, the evidence or anything. I'm trying to balance out what I see here. And 20 days does not seem unreasonable. I don't think, anyways, I'll leave it there.
So just for a question, if it were collapsed at 20 days, what does that do to the final number?
It's keeping the same adjustment factors, and that's my concern as we start doing too much with the adjustment factors. We have to be consistent over time with the people we're penalizing.
So if you kept the same adjustment factors that the prosecution team originally proposed, the amount would be $92,950. If you went with the change of the factors that Board Member Schneider proposed and collapsed the days, then you'd be, what did you say, around 60, 66.
So what you're saying is that the screen as is, if the only number that's changed is 30 to 20, that's the 66 number.
And including these other adjustment factors.
Yes. Yes, that's correct.
It seems like there might be a compromise that's a little obvious, but maybe splitting the difference between 20 and 30 and just make it 25 and move on, because I do recognize the staff has put a tremendous amount of effort into this, and that the respondent was negligent in responding, and we don't want to encourage that kind of behavior, and that this is in fact a precedent, and there will be a lot more of these cases, I'm sure, especially out of the Reading office. So I'll just throw that out there for consideration.
What was the reasoning behind collapsing this to the minimum 20 days? Carmen?
The reason is that, for me, I didn't see how 30 was justified. It sounded like they had originally, and this is in the testimony, this is what I picked up, that the number had originally been collapsed, and then somehow I got the impression that the number felt too low, and then so it was readjusted to 30, and I just, I think that on egregious cases, I think that that can be justified. In this one, I think that Mr. Vang bears a lot of culpability, but I think that his explanation makes sense. You know, I tend to believe that when he got the property, it was already like this. I don't think that he did it. I don't think that excuses him from liability, not at all. I think that he admits dodging service and avoiding this, and that's not the answer. And I don't think that that merits zero. I also think that, you know, severe culpability would be would be I could see it in a different situation. So for me, 20 seems reasonable unless 30 was justified in some other way.
Well, he talks about the roads he didn't do, but he did, I believe, grade out the grow plots for all of those plants and stuff, and that was just, you know, I mean, that was actually not discussed, but he didn't say he didn't do it. I'm gonna assume that he did. Somebody had to grade out all that extra land from where the roads were to provide the grow plots, and, you know, so we can have a vote. I'm gonna stick with 30, because I think that's the appropriate time.
Well, I'm going to leave the adjustment factors the same and go to 20, so he gets 2/3 of what the original penalty was. I think we're all in agreement. We need to give him a break on the monetary penalty, and just how we do it is a matter of discussion.
So at this time, I would make the motion to,
Well, just a second here.
Okay.
Okay. So, does the prosecution team have any further statements before we close?
No, sir.
Thank you very much. We'll go ahead and close the hearing.
So I would suggest, in terms of looking at what the grading activities were for the cultivation activities, I think the pictures that are in the back of your package might be informative for that. I think the Bates number came over very dark pictures, so I'd work back. It's just a couple pages back from page 249, and you can see the progression of the Google Earth images from August of 2013.
Open the hearing. Mr. Ving, could you come to the microphone, please?
And you can see this.
What grading did you do on the cultivation areas? So you're stating for the record that the cultivation area, as we see it in the pictures, is what you leased. Is that correct? Or that you bought, excuse me.
I rented the property out to some people, but it wasn't me.
Well, what they do on the property is your responsibility. Did the people you lease it to clear those areas?
So if you look at the images, it appears that there are the scarred landscape where there are clearings existed as far back as 2013. So it is plausible that there wasn't additional grading conducted, or at least not extensive grading, when Mr. Vang leased his property and cannabis cultivation occurred on the pre-graded areas of the property.
Okay.
And I would state the prosecution team's theory of the case is that Mr. Vang, as owner, had the ability to control that property and could have prohibited and remediated those portions which presented a risk to water quality.
Do you understand what's being said, Mr. Vang? That you owned that property and what anybody else may have done on that property, including a trespasser, is your responsibility?
I understand that.
Okay. Thank you very much. I'll go ahead and close the hearing at this point. We're going to limit discussion to board members and members of the advisory team. And the board members have had extensive discussion. Is there any more discussion? Don't hear any right now. Then I would ask the Executive Officer Advisory Council for their comments and recommendations.
I think with respect to the matter of the number of days, I think frankly, the board is engaged in a fairly healthy debate about the number of days. It is one of the areas within the enforcement policy where there's a great deal of discretion placed on the board to arrive at a number that fits the general contours of the case and provides a just answer. I think that that relatively unconstrained nature of the board's discretion in that matter does lend itself to these type of debates. Should it be 25? Should it be 20? Should it be 30? I think that I think the range of numbers under discussion are all supportable by the facts of the case. So really, it's up to the board to rest upon a number of days, and I would suggest somewhere between and including 20 or 30 days consistent with the enforcement policy calculation. I think it is reasonable, Bob Schneider's suggestion, to reduce the culpability and the cleanup and cooperation factors from 1.3 to 1.1 for both of those factors, which would result in a lower penalty amount. I think that's consistent with how the board has treated these types of cases in the past. Again, there is discretion in reducing those numbers, but I think that discretion is appropriately exercised and consistent with the enforcement policy. So realistically, I think the board can very well find a number of days between 20 and 30. It really rests upon the policy judgment of the board where that number should be.
And Mark has asked for 25 days, and if you could give us that number, so we just have another point of reference. I think 25 days is going to put us in the ballpark where we have seen in the irrigated lands programs violations that, in my mind at least, correspond to these.
It'd probably be right around, what, 70?
It's 83,187.
And that's consistent with what we've seen before, I believe.
And I think that, frankly, I think that would be more consistent with where the prosecution team came down, because the prosecution team issued a proposed order that suggests that it is reasonable to make an upward departure from the minimum number of days.
Right,
So if we were to say, no, we do want to go with the minimum number of days, we'd have to have a harder look at the findings as proposed by the
and
prosecution
possibly
team.
additional findings. So we can take further discussion, or I can take a motion.
And I have a procedural request. I would like to have 2 votes, one on the number and whatever's decided on, then that included in a resolution on the ACL.
So, and we can do that, and we can take a motion. I would
Well,
suggest.
I don't understand what he's asking. Can I get-
He's asking for, we find out of the board, focus down on the number of days, 30, 25, 20. And the other part that I would ask, though, I think there's consensus on the board, and if there's not, I'd like to hear it, that we would use the reduced factors in addition to that Bob has talked about. I'd like to get that cleared up right now, and hearing nobody object to that, then that comes down really then just to the number of days. And if we can arrive at that number of days,
And Carmen, I'm requesting that because while I may disagree on the number, I would like the opportunity to vote in support of whatever resolution we have.
now, since we're going to be doing that, possibly, and I'll ask advisory, our counsel for this, but conceivably, rather than doing a roll call, we could find what the consensus is possibly, or arrive at a consensus through discussion.
So what we would do in terms of working through this, we would need a roll call vote on the ultimate motion. And that ultimate motion would be to adopt the order.
That's right.
With
But
respect to the number of days, we can engage in a poll of the board if that was so inclined.
That's where I was going, yeah.
And walk through what every individual member would particularly feel like the appropriate number would be with respect to the number of days. I would also add, I think, I know, advisory team council also has some suggested changes to some of the other findings, just to make the ACL a little bit more defensible with respect to a couple of the proposed findings by the prosecution team.
Good.
But I would suggest that,
Let's do the poll.
Let's do the poll first.
And I suggest three dates, 3 numbers of days, 20, 25, and 30. So who would be in favor of 20 days? I see nobody stepping forth for 20 days. Who would be in favor of 25 days?
Aye.
1, 2, 3, 4, 5. Who would be in favor of 30 days? I see 5 for 25 and 2 for 30. Seems to me that at this point in time, 25 days has it. So would you?
I would just like to have a vote on that, please. That number.
You want a roll call vote?
Yes, please.
Okay.
We could do a roll call vote on the a proposed motion to make a motion for the ultimate penalty to include a assessment of 25 days.
Okay.
We could take the roll.
And, okay.
So
go
that's
ahead.
that's not the vote on the motion itself. That's on the ACL itself.
The two include 25 days, yeah.
Yeah,
It's
I
a
think
motion
this
to
is
put
just-
the motion on the floor, so it's essentially like
Okay.
a pre-hearing. It's not the final one.
Okay.
Is this just for the record of who is in favor of 25?
Absolutely.
So I think a board member should make that motion.
I move that we vote on 25 days.
Okay, do I have a second?
Second.
Mark's made the motion, it's been seconded by Carmen. Call the roll.
Mr. Bradford? Ms. Ramirez?
Yes.
Ms. Brower?
Yes.
Mr. Schneider? Dr. Markham?
Aye.
Ms. Kadara? Dr. Longley?
Yes,
Motion carries.
so we have 25 days. Now tell us what the other changes are.
I'll defer to Bailey as to that, but it has to do with some of the suggestions in the order, in the proposed order, that the maximum liability is constrained at $150,000.
Thank you, Patrick. So I have two categories of modifications to the proposed ACL that I would like to propose to you now. The first concerns adding findings adding findings 21 through 25 to just make it clear how the discharger was served here, the attempts that were made, and how service was ultimately accomplished. And the second proposal would be to clarify that the maximum civil liability that the board can impose under the water code is just that. It's based on what the relevant statute says in the applicable statutory section. It's not based on the alternate approach within the enforcement policy. And I can explain this more if the board would like me to. I do have proposed modifications that I can put up on the screen at this time, if that would be the board's preference.
Please put those up on the screen, and I also stated that I would be asking later if you folks wanted to go into executive session, but I think we've covered most of what we would cover in executive session. So I don't see a need for it at this time unless someone really wants it. And let me say, this device here, they put the names up on it, and it tells me who's ready to speak. And right now it tells me that Pamela Creedon's ready to speak. It kind of unnerves me.
I think Bailey's mic is still named Pamela Creedon.
Thanks, Adam. Okay, so as you'll see before you, the first subset of modifications would be to add findings 21 through 25, as seen on the screen. And again, that would just detail the attempts that the board staff made to serve the complaint and how that service was eventually accomplished. And I don't have copies, but if the prosecution team would like a copy at this time, otherwise I just have it on the screen here. And then below here, the second suggestion would be modifying findings, or within the order, 32 through 34, and those would be changed with the addition of the above findings. And again, that's just to make clear that the maximum civil liability is set by the statute under the water code. Based on the violation here of the cleanup and abatement order, the water code accounts for $5,000 per day and a minimum liability, and that the $5,000 per day and the $100 per day for non-discharge violation, that sets the ceiling and the floor for what the board can impose. And then the enforcement policy provides a framework to help inform the board's discretion and which ultimate liability to impose within this range. So here, I can scroll down. The maximum statutory liability that would be assessed, could be assessed under section 13350 of the Water Code would be $2 million, $2,200,000. Finding 37 just details the enforcement policy's mechanism for collapsing the number of days of violation, and that's ultimately how the staff had reached the number of 150,000. And I'm sorry, and then the modified finding 34, which would now be 38, then just clarifies that this the 150,000 would constrain the board here because that was put in the complaint as the maximum amount noticed. So that is the maximum amount here. Oh, and sorry, the final would just be to modify attachment A to the ACLO just to, again, clarify what the relevant statutory maximum liability would be.
So those are the late changes to the ACL that are being proposed by the advisory team. And at this point, I'd ask for a motion.
I'll make this motion. For the ACL on Mr. Vang's complaint, with all the late additions.
And with 25 days?
That's a late addition.
Late addition, okay. And the amount with the 25 days, once again, for the record?
So, sorry, if I can just interrupt. The late additions include making the days 25, changing the culpability factor to 1.1, and then changing the susceptibility to cleanup to 1.1 as well, just for the record.
That's exactly what I meant. Thank you so much.
And the final amount is?
$83,187.50.
Okay, and that motion has been made by Mr. Schneider, and I heard a second from Denise. Any further discussion? Call the roll.
Mr. Schneider? Dr. Markham? Mr. Bradford?
Yes.
Ms. Ramirez? Ms. Brower? Ms. Cordara? Dr. Longley?
Yes.
Motion carries.
Thank you very much. Who said this board doesn't work together?
Hopefully my calculator was dialed.
We're going to take about a 5-minute break very short break before we go on to agenda item 10. I need to decompress a bit after that one. Board's back in session. This is agenda item 10, and I have to, first of all, give my apologies to the dischargers in this order. If I mispronounce your name, and when you do come up, certainly correct me on that. But I'll go ahead and read the agenda procedures. This is the time and place for a public hearing to consider the administrative civil liability order for Conkeo Kamvangsa and Alexandra Kinsevoth of Shasta County. The designated parties for this proceeding are as follows. First, the board's prosecution team, and secondly, Conkeo Kamvangsa and Alexandra Kinsevoth. All of the participants are considered interested persons. The prosecution team has a combined total of 35 minutes for direct testimony, cross-examination, and a closing statement. Conkeo Kamvangsa and Alexandra Kinsevoth have a combined total of 30 minutes for the same. Interested persons shall limit their comments to 3 minutes, and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer, I do. Thank you. At this time, evidence should be introduced on the following issue: whether the board to issue, reject, or modify the proposed administrative civil liability order. The order of this hearing is as follows. First, we'll have testimony by the prosecution team, followed by testimony by Conkeo Kamvangsa and Alexandra Kinsevoth. That will be followed by cross-examination of the prosecution team. Then cross-examination of Conkeo Kamvangsa and Alexandra Kinsevoth. Then comments by interested persons, and finally a closing statement by Conkeo Kamvangsa and Alexandra Kinsevoth, followed by the closing statement from the prosecution team. Please state your name, address, and affiliation, and whether you've taken the oath before you testify. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Frankie Rizzardi, who's sitting to my right. Does Regional Board Advisory Team Council have any legal issues at this time to discuss?
Yes, as an initial matter, I wanted to note, again, as I did earlier for the previous ACL, that the prosecution team made a pre-hearing motion requesting permission to serve the complaint on Ms. Kinsevoth by publication, and the advisory team, after conferring with the board chair, granted this request and ordered service by publication. This ruling, in addition to the prosecution team's motion materials submitted in support, can be found in the prosecution team's Exhibit 29, and the prosecution team did since that order provide proof of the publication and a record of communication from Ms. Kinsevoth subsequent to that publication.
Thank you. Are there any procedural issues that the designated parties would like to raise at this time? Seeing none, we'll proceed with the prosecution testimony.
Good afternoon, Dr. Longley and members of the board. My name is Marisol Gonzalez, and I'm an engineering geologist with the Central Valley Water Board's Cannabis Regulatory and Enforcement Unit in the Reading office, and I have taken the oath. We are here today to ask you that you consider adopting an administrative civil liability order imposing liability against Conkeo Kamvangsa and Alexandra Kinsevoth, the owners of the site at issue. First, I would like to provide you with some general background and overview of this matter. The site which was developed to support cannabis cultivation, is located near the intersection of Ishii Road and Yolobali Road in the Trinity Alps Preserve, approximately 24 miles southwest of Redding, California, and approximately 23 miles west of Cottonwood, California, in Shasta County. The site sits above Fiddler Creek, a watercourse that is tributary to Middle Fork Cottonwood Creek, which supports anadromous fish species. 2 tributary drainages carry stormwater runoff to Fiddler Creek. Hilltop and hill slope grading occurred in close proximity to the tributaries. Grading to increase the size of a dam located on site occurred within one of the tributaries. The site has no prior regulatory oversight or history with the Central Valley Water Board. In February 2015, the Department of Fish and Wildlife Warden, conducting a patrol in the area, noted grading and earthwork on a dam which appeared to support cannabis cultivation. The warden passed this information to Central Valley Water Board staff, who contacted the property owner and gained consent to inspect the property. Staff conducted the inspection on March 20th, 2015. Due to the conditions noted, staff issued a notice of violation, or NOV, to the owner of the site, Mr. Singh Bungdavath, which outlined the need for remediation activities. In August of 2015, the property was sold to cousins Kangeo Kambongza and Alexandra Kenzavoth, and a proposed restoration plan was submitted by Vestra Resources, Inc. the same month. A final restoration plan was submitted on October 7th, 2015. In December of 2015, staff conducted a visual inspection from Yolobali Road and noted that no remediation work had been completed. Due to the failure to complete restoration work requested in the NOV, a draft cleanup and abatement order was issued in May 2016. After receiving no comments on the draft cleanup and abatement order, a final cleanup and abatement order was issued in June 2016 to Kangeo Kambongza, Alexandra Kenzavoth, and Singh Bungdavath. The cleanup and abatement order required that the parties to submit and implement a restoration, monitoring, and mitigation plan referred to as an RMMP. The RMMP is a plan that outlines the restoration work to be completed on site, including a timeline for completion and proposed monitoring to ensure that restoration work is successful. In August of 2016, staff issued an NOV for noncompliance with the cleanup and abatement order. A second NOV was issued in February of 2017. During August of 2017, staff conducted a follow-up site inspection. No restoration work or remediation work had been completed, and the conditions of the cleanup and abatement order had not been met. As a result, staff issued a third NOV in April of 2018. Due to the continued noncompliance with the final cleanup and abatement order, the Assistant Executive Officer issued Administrative Civil Liability Complaint R5-2018-0529, referred to as the complaint, to Mr. Kambongza and Ms. Kenzavoth on November 13th, 2018. On November 20th, after the issuance of the complaint, Fish and Wildlife invited Central Valley Water Board staff to accompany them on a consent-based inspection of the site. Staff have not finalized this inspection report at the time. However, observations would not have altered the penalty assessment. For purposes of this complaint, the prosecution team is only seeking administrative civil liability against Mr. Kambongza and Ms. Kenzavoth. After purchasing the property, Mr. Kambongza and Ms. Kenzavoth indicated that they were aware of the cleanup and remedial action and that they would undertake the corrective actions required. However, they failed to complete any of the required work and in fact expanded the cultivation area beyond what had originally been developed by Mr. Bungdavath. In the preceding presentation, I will only discuss Mr. Kambongza and Ms. Kenzavoth's involvement with the site. During the March 2015 inspection, staff identified several primary areas of concern, such as an earthen dam, 5 graded pads, and trash left on site. This figure, taken from the inspection report, displays the basic site layout observed during the inspection and the areas of concern. The red diamond waypoints represent the location of the graded pads. Photo 1, looking north, is a view of the earthen dam. And photo 2, looking west, is a view of the pond. The earthen dam on site runs north-south and does not have a constructed outlet. The earthen dam interrupts the flow of surface water down a natural drainage pattern on the property. Photo 3 is a view of the downstream face of the dam. Staff observed tension cracks, rills, and gullies from stormwater runoff. Photo 4 is a view of the pond slopes upstream of the dam. And again, staff documented rills and gullies created from stormwater runoff, resulting in turbid water in the pond.
Marisol, if you could speak a little more directly into the microphone for the record. Thanks.
5 graded areas were observed. Staff estimated land disturbance to be in excess of 1.5 acres. Photo 5 is a view looking west at an excavated wall and the graded pad. The graded pad was being utilized for cannabis cultivation. Photo 6 is a view of slumping and unstable soil resulting from the creation of another graded pad. Runoff from this area moves downhill towards a seasonal tributary of Fiddler Creek. The unpermitted excavation and grading activities resulted in discharge of waste to tributaries of Fiddler Creek. Due to the conditions noted during the inspection, staff issued an NOV to Mr. Bungnavath on July 6, 2015 via certified mail. As previously discussed, Mr. Bungnavath sold the site to Mr. Kamvangza and Ms. Kenzavath in August of 2015. Shortly after Mr. Kamvangza and Ms. Kenzavath acquired the property, Vestra Resources, Inc. submitted a remediation plan to address the NOV. Vestra submitted an initial remediation plan on August 14, 2015, followed by a final remediation plan submitted on October 7, 2015. Under the final plan, remediation work was to be completed by December 31, 2015. On December 1, 2015, staff conducted a drive-by inspection and observed that no remediation work had been conducted. Due to non-compliance with the July 2015 NOV, the Assistant Executive Officer of the Central Valley Water Board issued a draft cleanup and abatement order on May 12, 2016, which provided a 19-day comment period. The draft cleanup and abatement order sent to Mr. Kamvangza and Ms. Kenzavath was signed for, and the certified mail receipt was received by staff on May 20th, 2016. After receiving no comments, the final cleanup and abatement order was issued on June 27th, 2016. The cleanup and abatement order sent to Mr. Kamvangza and Ms. Kenzavath was signed for, and staff received the certified mail receipt on July 1st, 2016. The final cleanup and abatement order included a series of required actions to restore and mitigate the conditions of the site. Ultimately, a restoration, monitoring, and mitigation plan, referred to as an RMMP, was to be completed and implemented by October 31st, 2016, with a completion report due by December 1st, 2016. As previously mentioned, the RMMP is a plan prepared by the discharger that outlines the proposed remediation measures to restore and mitigate the site, as well as outlining subsequent monitoring effects that would be performed to ensure the implemented measures are performing as intended. Mr. Komvangza and Ms. Kenzavoth failed to complete initial actions required in the cleanup and abatement order and did not develop or submit an RMMP by August 1st, 2016. Therefore, an NOV was issued on August 11th, 2016, notifying them of the violation and their noncompliance could result in a monetary liability. The NOV was sent via certified mail to all parties listed on the cleanup and abatement order. The copy sent to Mr. Komvangza and Ms. Kenzavoth was signed for, and certified mail receipt was received by staff on August 22nd, 2016. During August 2016, Mr. Komvangza called the Central Valley Water Board to discuss the cleanup and abatement order. Staff explained that the cleanup and abatement order process to him. He stated that he had cleaned up the trash on property. Staff informed him that the cleanup and abatement order process and explained that the cleanup and abatement order was issued to ensure cleanup of waste resulting from grading and dam construction. Staff encouraged him to read and fully understand the cleanup and abatement order and recommended that he retain a consultant to assist in complying with the cleanup and abatement order. On February 13th, 2017, staff sent a second NOV via certified mail for failure to complete the actions required in the cleanup and abatement order. The copy sent to Mr. Komvangza and Ms. Kenzavoth was signed for, and staff received the certified mail receipt on February 22nd, 2017. The NOV requested all documentation required in the cleanup and abatement order by no later than March 6, 2017. Staff did not receive a response or the required documentation. During August 2017, Department of Fish and Wildlife wardens obtained a warrant to search the site, which authorized staff from the Central Valley Water Board to participate. The conditions observed were similar to those in the March 2015 inspection. No restoration or remediation work had been completed, and the conditions of the cleanup and abatement order had not been met. As a result, the site continued to pose a risk of sediment erosion and discharge to tributaries of Fiddler Creek. In addition, the cultivation area had expanded to 3 additional areas beyond what was originally documented in 2015. Improper best management practices to control erosion and sediment discharges had not been implemented. The 3 additional cultivation areas expanded total site disturbance from approximately 1.5 acres to approximately 2.66 acres. Due to the continued noncompliance with the cleanup and abatement order, as documented during the August 2017 inspection, staff issued a third NOV on April 25th, 2018 via certified mail. The NOV requested all documentation required in the final cleanup and abatement order by no later than May 25th, 2018. On June 16th, 2018, the NOV was picked up by Mr. Komvangza. Staff sent the NOV to Ms. Kenzavoth at 2 different addresses, but were both returned as undeliverable. On September 19th, 2018, staff remailed the NOV to Ms. Kenzavoth at an address in Redding, California, but this package was also returned as undeliverable. On October 10th, 2018, staff resent the NOV to a 4th address located in Fresno, California, which she received and signed for on October 18th, 2018. Because they failed to complete the action required in the cleanup and abatement order, the Assistant Executive Officer issued the complaint to Mr. Komvangza and Ms. Kenzavoth on November 13th, 2018. Mr. Komvangza received and signed for the complaint on November 23rd, 2018. The complaint was sent to Ms. Kenzavoth via certified mail delivery and first-class mail to 2 addresses where she had previously received certified mail, one in Banning, California, and another in Fresno, California. Delivery in the Banning address was unsuccessful. Delivery at the Fresno address was attempted on November 15th and December 3rd, 2018. However, the complaint was not claimed and was returned to staff on December 17th, 2018. Because certified delivery was unsuccessful, the prosecution team provided the complaint to a process server for personal service at Ms. Kenzevoth's Fresno address, where she had accepted the certified delivery of the April 2018 NOV. The process server attempted delivery on November 28th, 29th, and 30th, and December 3rd, 2018, but was unable to deliver the complaint to Ms. Kenzevoth. On December 3rd, the process server posted the complaint on the door of the residence. On December 6th, 2018, the prosecution team submitted a pre-hearing motion requesting permission to serve the complaint on Ms. Kenzevoth by publication in the Fresno Bee, which the board's advisory team granted. The prosecution team published the notice in the Fresno Bee on December 27th, 2018, and January 3rd, 10th, and 17th, 2019. On December 14th, 2018, Mr. Kamvangza emailed the prosecution team to confirm that he needs to attend the hearing set for February 7th and 8th. The prosecution team responded to Mr. Kenzevoth on December 17th, 2018, and informed him of the purposes of the hearing and the potential for a default judgment if he does not attend. The prosecution team received no further response from Mr. Kamvangza. On January 28, 2019, Ms. Kenzevoth contacted the prosecution team via email. On January 29, 2019, the prosecution team followed up with Ms. Kenzevoth by phone to discuss the notices in board hearing.
And what was the result of that discussion?
The result of the discussion was Ms. Kenzevoth was asking about the hearing process and bringing up potential inability to attend based on a work schedule. There was really no conclusion to that conversation other than to state that the board hearing is scheduled for the 7th, and similar to Mr. Kamvangza, that if she does not attend, it could potentially default in a judgment.
Mr. Kamvangza and Ms. Kenzevoth's failure to complete and implement any of the actions required in the cleanup and abatement order resulted in multiple violations. However, the prosecution team is alleging only one violation based on failure to implement an RMMP, which was required to have been completed on October 31st, 2016. Using October 31st, 2016 as a start date and the end date of November 13th, 2018, the date the complaint was issued, there was a total of 744 days of violation. However, the prosecution team utilized the alternative approach for multiple day violations under the enforcement policy, which allowed for the collapsing of days. Staff utilized a full collapsing of days, resulting in 30 days of violation. Using 30 days for the violation, the statutory maximum and minimum penalties allowed under the Water Code Section 13 through 50 is $150,000 and $3,000 respectively. However, the enforcement policy provides that the minimum civil liability imposed must be at least 10% higher than the economic benefit. Since the economic benefit plus 10% is higher than the statutory minimum, the minimum liability amount for this case is $3,341. After following the penalty calculation procedures outlined in the enforcement policy, the prosecution team issued the complaint to Mr. Kamvangza and Ms. Kenzevoth in the amount of $150,000, the statutory maximum for the violation. The table on this slide summarizes the factors the prosecution team utilized when calculating the proposed liability. For potential for harm, the enforcement policy gives a range of minor to moderate. For this violation, the prosecution team utilized a moderate potential for harm, noting that Mr. Kamvangza and Ms. Kenzevoth's failure to implement the RMMP could have reasonably caused additional sediment discharges to the tributaries of Fiddler Creek. For deviation from the requirement, the prosecution team used major due to Mr. Kamvangza and Ms. Kenzevoth's failure to implement the RMMP, rendering the cleanup and abatement order ineffective in its essential functions. As stated in the previous slide, the prosecution team utilized an alternative approach to penalty calculation for multiple day violations, thereby collapsing the days of violation to 30 days. I couldn't hear.
This is Bob. Could you go back one slide, please?
One slide?
Yeah, you have the complaint issued for the maximum amount of $150,000. That isn't the maximum amount that could have been assessed for the penalty. That was the maximum amount based upon the collapsed days, correct? Because I think we want to put what could have been the total maximum amount in the findings.
That is correct from the prosecution. Sorry.
Thank you.
And in the event you're asking me, as an advisory team will propose revisions based on your comment.
Should I move forward?
And I suspect that maximum amount is well over $1 million, possibly over $2 million.
Upwards of 2.3 million.
Yeah, that's what I would suspect. Thank you.
Actually, it's 3.7 million.
It's a little more than I suspected.
Continue or?
Continue, please.
Thank you. The enforcement policy states that culpability shall be assessed on a multiplier between 0.5 and 1.5, with higher values used for intentional or negligent violations. Mr. Kamvangza and Ms. Kenzevoth were aware of the requirements to clean up and remediate the site. However, they chose not to comply with the cleanup requirements. Therefore, the prosecution team utilized a factor of 1.4. Cleanup and cooperation is defined as a multiplier between 0.75 and 1.5, with a higher multiplier when there is lack of cooperation. Mr. Kamvangza and Ms. Kenzevoth have failed to act on numerous notices of violation and the requirements of the cleanup and abatement order, and have actively expanded the cannabis cultivation operations since the issuance of the cleanup and abatement order. Therefore, the prosecution team utilized a value of 1.5. Mr. Kamvangza and Ms. Kenzevoth do not have a history of repeat violation with the Central Valley Water Board. Therefore, the prosecution team assigned a neutral value of 1, which does not affect the penalty.
I have a question about that. Now, they were being assessed a penalty, this violation, and then, correct me if I'm wrong, but my understanding is they were supposed to implement this remedy. They didn't do that. They went and expanded their facilities. So how come that, can that be 2 violations? Or we would assess a penalty on the other expansion without proper procedures, or? I mean, when does 1 become 2 in this sort of case is basically my question.
I think I would, in this case, I would invite the prosecution team to comment on the prosecutorial decisions that they made with respect to that, because I think we could cut it up a few different ways, but you know.
No,
it's up to
I
them to-
respect that,
yeah.
and I respect their thing. I'm just making, this to me is pretty flagrant when they're under, I mean, should at a future date they decide, oh, they may have had another violation, they
Yeah.
can do that, but
No, I
we're
would-
just working on 1 complaint as this is trying to finish this through.
I would absolutely suggest that the prosecution team answer.
So for consideration on the history of violations, because the violation alleged is for a violation of the cleanup and abatement order, which was already existing, that's what we utilized to determine that it was still just a violation of the cleanup and abatement order, not necessarily a separate violation than what's being alleged in the complaint.
Interesting that you say that, because at some point in time, after the initial violation, there was another violation.
Yeah, and I think just to expand on that a little bit, we have several opportunities to identify violations associated with the failure to comply with this cleanup and abatement order. The reality is each time you identify a violation and pull it into the penalty calculation, the penalties increase dramatically. And so the prosecution team, in sort of weighing the factors available to us, decided to proceed with the one that we're talking about here.
Thank you.
Using the factors discussed, the total base liability for this violation was calculated to be $189,000. However, since the maximum penalty allowed under Water Code Section 13 through 50 is $150,000, the total base liability becomes $150,000. The effect of the total base liability amount on the violator's ability to pay and continue in business should be considered, and the total base liability amount may be adjusted to address the ability to pay or continue in business. The prosecution team performed an asset search using publicly available information, but this information was extremely limited, and neither Mr. Kombangza or Ms. Kenzavoth have submitted additional financial information. Therefore, the prosecution team considered this factor, but determined it did not have sufficient information to warrant an adjustment. To summarize, the clearing and grading activities conducted at the site resulted in the unauthorized discharge and threat of discharge of waste into waters of the state. The cleanup and abatement order was issued to Mr. Kombangza and Ms. Kenzavoth for the purpose of cleaning up and abating these discharges and threats of discharges. Mr. Kombangza and Ms. Kenzavoth had the legal ability and legal responsibility to comply with the cleanup and abatement order. Staff provided numerous opportunities for Mr. Kombangza and Ms. Kenzavoth to come into compliance and remediate the site. However, they chose not to complete the remediation activities required under the cleanup and abatement order. Thank you. One more slide? Oh, yeah, I do. For all of these reasons outlined, the prosecution team recommends that the board adopt administrative civil liability order in the amount of $150,000. And we request this presentation and all evidence exhibits be admitted into the record for this matter.
And it will be admitted to the record, and thank you for your presentation.
Thank you.
Any questions from members of the board? We'll take now testimony by Kankeo Kamswangsa and Alexandra Kenzavoth. I have a card from Mr. Kankeo Sir, you'll have to help me with your name. Kamvangsa, is that correct? Come up to the platform, please. It says on this card that you're representing yourself and Alex Kenzavoth. Is that correct?
That'd be correct, sir.
And it says on this card that everything was done on the property was done without, you say, my knowledge, to include the purchase of the property. Is that correct?
That is correct, sir.
Okay. Could you go ahead and provide the testimony you desire to give this board?
My name is Kankeo Kamvangsa. I have taken the oath. I am a U.S. Air Force veteran. I've been living in Milwaukee, Wisconsin for the past 15 years. So I'm not sure how the land was purchased with mine and my cousin's name on there. So I have never signed any paperwork to purchase this land. So my knowledge of what was happening with the land or what happened on the land was never noted until I received a notice of violation. After I received that, I tried to do the right thing and ended up cleaning up the property. And then Ms. Freeney with the Department of Fish and Wildlife went back out to inspect the property and said that the cleaning that was done was satisfactory. So with that, I'm really not sure. I contacted Vestra to see what was needed to be done. They said that it would take about $15,000 to get the place cleaned up and stuff, which I do not have that kind of money to pay them to do that. So I went out with some family, and we end up cleaning the property of a couple 100 pounds of garbage and debris. And that's pretty much all I have, sir.
Do you have any questions of the prosecution team? That was the people that were just sitting up here presenting the case against you. Do you have any questions of them?
Not at this time.
Okay, does the prosecution team have any questions of Mr. Convongsa? I'm waiting for an answer. Okay.
Good afternoon. My name's Heather Mapes. I'm counsel for the prosecution team. Good afternoon, Mr. Kamangza.
Good afternoon.
So you stated you've lived in Wisconsin for how long?
The past 15 years.
So you've never previously resided at 417 East George Street in Banning, California?
That is correct.
And what is your relationship to Linda Razbanoff?
That is my mother.
Okay, and has she previously lived at 417 East George Street?
Yes.
Okay. And so you said you weren't aware of this until you received the NOV. Which NOV were you talking about? We've had several.
I believe it was the one that was received in the fall of 2016.
And did you, so that NOV, I believe, was sent to that address in Banning?
Correct.
So you learned about that from your mother?
Yes.
Okay. And then you said you've talked to regional staff about the cleanup and abatement order, correct?
Correct.
Did you receive the draft cleanup and abatement order that was sent to the Banning address?
No.
Okay. Are you aware that your mother signed? Or are you aware of who signed for that?
No.
Okay. And what about the final CAO that was issued? Did you get a copy of that?
Can you remind me of the date on that one?
That one was I think May 2016. I think it was in May 2016, but we can May 12th, 2016.
I do not remember if I did or not.
Okay. But you learned about the CAO and talked to regional staff about the requirements?
Yes.
And did they explain to you that the requirements extended beyond cleaning up the trash?
That I do not remember.
Okay. So you mentioned that you brought family, you cleaned up the site, or you cleaned up trash from the site. You did that despite not owning the property?
Correct, because I thought I was doing the right thing to help out and to kind of rectify the situation.
Have you contacted the county about your belief that your name is listed on the deed improperly?
I have not, because I do not know who to contact.
Okay. Are you aware of who does own the property or who should own the property?
I do not.
Okay, so you didn't contact anyone before going out to the property to clean up the trash?
No.
Okay. Thank you. That's it.
Thank you. Do board members have any questions for Mr. Kamvangsa?
Yes, I do.
Go ahead.
So you did not purchase this property.
That is correct.
So you did not take any steps to contact anyone regarding fraud. You felt like there was fraud happening at all. You have not done that.
Correct. Said I still don't know who I need to go through because I've been trying to find a lawyer through the VA or personally to try and help me with the situation. And I have very limited contact from anybody in regards to being able to help.
But you went and cleaned up the property.
Yes.
Correct. Okay. And this other person listed on the deed, who is that to you?
It's my cousin.
And did you talk with her about this?
No, actually, today is actually first time I've seen her in over 20 years.
Have you communicated by telephone?
Just recently.
Thank you.
Do you,
Go ahead, I'm sorry.
I'm curious to know what that conversation consisted of.
That was just that I told her because I finally saw the email come across saying that there was the order that was put in the paper for her.
Did she know about the purchase of this property? Or does she feel somebody signed for her as well?
She feels the same way that somebody signed for her.
Thank you.
If I could ask, how did you find this property?
I did not find this property, sir. I do not know how they find this property. My parents knew about the property, where it was located.
Because there's not really an address there, right?
Correct.
So you got a letter from the board saying that this property had problems.
Mhm.
You came from Wisconsin to clean up the property
Yes.
without really ever knowing even where the property was, an address for the property.
That is correct.
Okay.
Very good. Any further questions from members of the board?
I'm confused.
Can we
Yeah.
ask prosecution
But-
teams?
Dan, go ahead.
I do, go ahead.
Go ahead,
I'm
Bob.
just curious, who did the expansion of the grow sites?
I'm not aware of what happened, even from the purchase to when the first notice of violation was given.
I'm still confused, but
Go ahead. Go ahead, Dan.
Who's paying the taxes on this property?
From what I've seen, nobody has been paying the taxes on this property. So for the property itself, I just got a letter stating that the property has been repossessed as of February 1st.
Did you bring that documentation with you?
I did not.
Go ahead, Mark.
Yeah, I was going to ask the same question that Dan asked about the taxes, or whether there's any financial records about the transaction that it was involved in acquiring the property. Seems odd. Somebody had to pay for it, right?
Yeah, we do have a copy of the deed transfer document and the evidence exhibits. It does list Alexandra Kenzaveth and Congeo Kamvongsa as the receivers of the deed. However, it doesn't have signatures associated, just list who the parties involved are.
Is that what's on page 171?
That's correct.
And then the other documentation we have related to the ownership is when we were originally getting involved with the site, the mailing address listed for the site ownership was in Banning, California, and it recently, as of issuance of the notice of violations and the complaint, the mailing address listed with the property has been updated to Mr. Congeo's address in Wisconsin. So there has been changes made to the ownership records.
Let me say this, Mr. Kambangsa, I find your explanation that you did not know what was going on not too believable, one way or the other. And the fact that you didn't bring documents with you, or at some point you or a member of your family did not start a search to find out who was listing your names, particularly when you were receiving correspondence from this board saying that you had some issues with this site, strikes me as not believable, quite frankly. But we'll see what the rest, how my fellow board members feel about this also. Are there any further questions for Mr. Kinsovath? Thank you very much, sir. If you so desire, you can give this board a closing statement.
I really don't know what else I can say, because I truly don't know what was going on with the property. Living out in Wisconsin, I travel a lot for work, so it's hard even to get over here, even when I was trying to clean up the property and that. So I was just trying to do the right thing to get it cleaned up and stuff like that. So I guess if that makes me a bad person, I guess I get fined for something that I really didn't do, I guess.
Well, you were at least negligent in not following up on if in fact fraud was performed against you. You're negligent in not following up on that and bringing to this board the evidence that you are not in fact the person who bought this parcel, and that this parcel this land should not be in your name. We'll see what the board does. You do have a recourse, and that, of course, is if the board decides against you and imposes a penalty, you can always take that to the state board. And if that happens to be your course, I would certainly hope that you would show up with the evidence to support the statements you've been making. With that said, thank you for your testimony, and we'll move on. At this point in time, the board's ready for closing statement by the prosecution team.
Dr. Longley, just maybe a matter to bring to your attention just before I provide my closing statement. The complaint names two parties. We've only heard from one. I don't know if it'd be worth touching base to see if the other party is here and would want to say anything.
That's a good point. Is Alex Kinsovath in the audience here today? Do you have a statement to make? Could you come up to the podium for a moment, please? I am going to ask you a couple of questions, so I appreciate if you could take the oath. Could you raise your hand, please? Is what you're about to state the truth, and if so, answer I do. Thank you. The statements that were made to us by Mr. Kamvangsa, does he fairly represent you?
Yes.
Do you have anything to add to what he stated?
No.
Thank you very much. With that said, could I have final statement? from the prosecution team.
Sure. Clint Snyder again, Assistant Executive Officer, Central Valley Water Board's
I have
ready.
a question first, Clint, if I could. I'm trying to figure out the difference now. This sale history, this transfer occurred on August 13th, 2015, from Singh Bungnava to the other folks. And Vespa was hired also in Vestra, August 2015, and I can't recall, but who hired Vestra? You hired Vestra.
Ma'am, could you come up here because it needs to be on the record? And could you raise your right hand, please? Or what you're about to state to this board, is it the truth? If so, answer I do.
I do.
Thank you. And could you state your name, please?
Kendra Anderson.
Okay, and what is your relationship to the other two parties?
I am the mother of Alexandra, and I am the aunt of Bobby.
Very good. And you hired Vestra.
I hired Vestra for Mr. Sang, the original owner, to try to get that all cleared out. And that was the only thing. And then when he didn't pay Vestra, I backed out because I was only doing him a favor in getting them to go out. And when he used my name for Vestra and he didn't pay them, I said, I'm not doing anything for you no more.
And I'm sorry, who is that other?
San, the original owner.
Right.
And so you did this as a favor for Sam.
Yes, I did.
Do you have like a familial relationship with Sam? Is
I
he
would
related?
say I looked to him as a big brother, and that was it. We
Okay.
knew each other from friends, and then he just said, look, can I use you? You speak good English. I don't speak good English. Could you help me out? And I said, what is it? As long as, I'm not doing anything wrong, something that's not, illegal, I can help you.
Yeah.
And that's what I did. I went out there, I talked to Vestra and said, could you come out? We're having problems. I don't know what's going on, but this needs to be done. Could you let me know what this land needs to be worked on?
Okay. And is Sang here today?
No.
Singh, it seems to me then, talked to you, he never talked to Bobby or Alexandra.
No.
He doesn't know who the heck they are.
No. And I can
So
vouch
how do you
that,
sell them
yeah.
the property? Well, we have our job here is about water quality, and I'm gonna get back
Yes.
to that. Your job's gonna be to sort it out with the responsible parties, and that is some sort of a judicial criminal case, I suspect.
Also
And-
with evidence.
And, I can't see here what the recorded signatures are, because they're all notarized about who signed what for who, but, to some extent, a decision will have to be made whether your signatures, those signatures are real signatures or a forgery or not. And I don't know if that affects our prosecution or not either, but I think I'm clearing up in my small brain here a little bit of the confusion that I've been feeling about this whole thing. So, thank you.
Okay, any further questions?
I guess just following up on that, it seems like the $64 question here is who really owns this property and how did their names get on it if it wasn't them that bought it, and or if there was another family member involved or somebody that knew them. That seems to be the crux of the matter here, and I don't see how we're going to resolve that here in this hearing. But like Bob said, I think we're just looking at the water quality ramifications.
We're looking at the water quality, and we're using what we have in front of us, some notarized documents that attest to something. And I think it's not within, the attorneys can certainly correct me on this, but I don't think it's within our responsibility to determine whether or not those items, those papers, those deeds, if you will, are valid. They're presented to us as being valid. I have to accept them at face value. If council says something else, then that's,
Dr. Longley, you're 100% right. I mean, that's not our purview. And in fact, you know, for me as an individual board member, you know, the testimony makes my decision very, very easy because, you know, you impose the maximum liability and then you wait until, you know, they hire civil counsel to untangle this. But it's not our job to untangle it. It's our
right.
job to see whether there's any extenuating circumstances that would warrant a reconsideration of the recommended amount, and there are none. In fact, there's, you know, no legitimate party. I mean, I know you guys are the real people, but no legitimate party here to answer. So this one seems really, really easy to me. So I intend to support staff's recommendation.
I agree.
very good.
The only other consideration I would have is that when we do an ACL, they're doable and pay right within 30 days, aren't they? Or,
Correct.
so if we do this, these folks are on the hook immediately.
So,
And I don't know if that's really our consideration
yeah.
or not either, but
If they do petition it to the state board, it is not due until that petition has been either dismissed or determined.
Right, and Corinne, I would appreciate it very much if you could help this lady fill out a blue card. And thank you for your testimony. Before you leave, we'd like your contact information.
That's fine.
Thank you. Thank you very much.
so I'm going to support this also, but I'm hoping that maybe staff could just inform these folks what the process is for them to appeal it to the state board.
And for what it's worth, we have done that, and we did do that with the subsequent ACL as well, and gave the individual the site. I am curious whether they're on page 265 of your agenda. There's a email entered into the record between Marisol Gonzalez and Toby Freeney with the Fish and Wildlife. Toby Freeney, who's not here today, states in that email that Mr. Kambongza stated that he owned the property with a relative and was not aware of what had occurred on the property in regards to the tenants and lessees. If it's the board's pleasure, I would suggest that the board ask Mr. Kambongza if he did in fact talk to Mr. Freeney on that matter, or Mrs. Freeney, I don't know the gender of Toby Freeney, as to whether that conversation took place and what the substance of that conversation was.
And
we also have a sworn declaration from Toby that that conversation took place and the substance of that conversation.
Okay, we're going to ask you to come back up here again, Mr. Komanska. And do we have I have a copy here. That's page 265. Could somebody furnish Mr. Komanska with a copy with that page?
It's Exhibit 26, I believe.
Exhibit 26, right. And if you could read that statement and tell us that, and remember, you've been sworn. Could you relate to us whether or not the statement there by Toby Freeney is correct or not?
The statement says, I had a phone conversation on 11/27/17 and 4/2/18 with regards to the property and the required remediation. During one of those conversations, I believe from November, Mr. Kambongsa stated that he owned the property with a relative and was not aware of what had occurred on the property in regards to the tenants/lessees. I explained the condition of the property was ultimately the property owner's responsibility, and he said he wanted to do what needed to fix the property. I do remember having this conversation with Ms. Freeney. So,
Is it correct, as Mr. Freeney states here?
I did tell Ms. Freeney that I would take care of that. I would try and fix the situation.
And he's saying here that you stated that you own the property with a relative.
It was a Miss Freeney, just for the record.
Pardon?
Miss Freeney. I've been
Miss
told.
Freeney, I'm sorry. So Miss Freeney stated that you said that you own the property with a relative. Is that correct?
I do not remember stating to that I own the property with a relative.
Is that statement correct or not in your testimony?
In my opinion, I do not believe it is correct.
A more direct question. Do you own the property? Are you a part owner of the property or not?
I am
Under
not.
oath, you are not.
Thank you very much. I think we're ready for our closing statement from the, yeah, from the prosecution team.
Clint Snyder, Assistant Executive Officer with the Central Valley Water Board. Dr. Longley, members of the board. I think what you're seeing here today, quite frankly, is a lot of what our staff and our council wrestle with for many months on a lot of these cases to try to get to the bottom of not only ownership, but transactions. They happen frequently and they happen often. We've learned more today than we knew coming into this trial, or this hearing, excuse me. The lack of communication with the dischargers in this case has been frustrating. We rely on documentation from county records and other legal documents that we can uncover to try to identify the owners of these properties. We don't believe that there are errors in the records that we've presented to the board. That said, it's a complicated case. There were both threatened and confirmed discharges of waste to waters of the state in this case, and we believe that the penalty amount is adequate given the circumstances. I would recommend that you adopt it as proposed.
Thank you very much. Before I close the hearing, any further questions of the prosecution team? Seeing none, then I'll go ahead and close the hearing. And I'll ask for comments from the executive officer and an advisory team council as appropriate. I believe council stated that we were going to have some additional language that was being proposed to us.
That's absolutely correct. I think there's a couple things that Ms. Toft Dupuis is suggesting that we add to reflect the fact that the maximum civil liability is not $150,000, but rather the upwards of over $3 million under the statutory scheme. That said, because of the way the ACL was noticed, the ceiling for today is $150,000 because we noticed that as the maximum. We can't go above that. But just to correct the record and make it absolutely clear that the statutory maximum is far, far higher than that, Bailey will have those modifications in front of the board shortly. My recommendation is to move forward with the ACL as proposed. I think we have a very murky case. I think it is entirely plausible that Mr. Sang Bongzavath, perhaps through Ms. Anderson, perhaps not, tried to get rid of some liability for a property in which he was growing drugs to somebody that he barely knew or did not know at all. But in California, the buck stops with the property owner. That's the way our water quality laws are structured, and that's the way this case is being charged. I think that the board has heard contradictory evidence about who the ownership of the property is, but I think the board is entitled to rely upon the deed records and the other sworn testimony or attested declarations that are in the record, suggesting that it is Mr. Kankyu Kangsomva and Alexandra Kenzavath who own this property and who ultimately face responsibility for this property. So with that, my recommendation would be to adopt the order as proposed. if circumstances were a little different, and if perhaps the ACL was charging, suggesting noticing a maximum liability of greater than $150,000, I think the board could entertain changes to the penalty calculation, but it is at this point a bit of a moot point because of the ceiling set by the notice that said $150,000 is as high as we can go. So even under the calculation, even though it results, I think, in a calculation of about $180,000 some dollars, the ceiling set by the notice would be $150,000, and I suggest that the board apply that as proposed.
And if I can interpret a bit of what was said previously by Mr. Maris, we are focusing on the documents in front of us. If there is an issue with those documents, then it is the responsibility of the individuals so impacted to proceed the appropriate legal solutions, remedy to that, to where their names are appearing. If it turns out to be improperly, they need to correct that. And there could be some solution following that.
I will ultimately say that I do empathize with Clint and his prosecution team and the Office of Enforcement Attorneys who try and chase down these particular operations. Where cannabis is being grown, both illegally and legally within the state of California, there's a tremendous amount of cash changing hands. That cash does not always reflect itself in the transactional documents that appear in court reporters. It does not always reflect itself in the transactions that banks are privy to or that clerk recorders record, because this is still largely a cash industry. Until it's brought into the daylight, one way or the other, this will continue to be a cash industry, and we're going to continue to have problems tracking down ownership. There will be leases done by handshake agreement with piles of cash changing hands, and that will continue to be opaque for the board in terms of tracing down the true owners. But like I said, I support the ACL because I think all due diligence was exercised in exerting notice to the parties who are named in the deeds, and in California, the buck stops with the property ownership as reflected in the county recorder's office.
Very good. Any questions or comments?
My comment is that we're capped at, that I'm disappointed that we're capped at 150. I understand the noticing, but this is the kind of case where, you know, you'd want to make it an alarmingly high number so that the responsible parties would be found. I know that maybe for the parties here, 150,000 is already so high that it's alarming, but this is really egregious, and this is terrible. So I'm sure other people have comments, but I will make a motion that we apply. Well, I'll tell you exactly.
Just before you make a motion, so you can incorporate it, could you present to us the changes? And then I'll accept your motion.
I just have one quick change too to make while I'm up here. If this. Okay. So the proposed modifications to the ACLO, again, are two different categories, as Patrick said earlier. One proposed modification would be to finding 19, just to make it clear that after the staff had published notification of the complaint, Ms. Kensavath had contacted them and indicated that she received notice, and she's here today. And then the additional modifications that are proposed are again to reflect that the maximum statutory liability that the board may assess under the water code, in this case, would have been $3.7 million, but it's limited by the 150 that was noticed in the complaint. And those additional modifications to attachment A to the ACL reflect that same reasoning that it's the water code that sets the maximum.
So I would move that we issue an administrative civil liability order with the updated changes as proposed by Council Toft Dupuis.
Do I have a second?
I'll second it.
Carmen made the motion. That's with the late revisions. Dan seconded with the late revisions. Is that correct, Dan? Yes. And so, any comments?
I'd just like to make one comment to the property owners. This session today was a testimony, opportunity for testimony from the prosecution and from your group to let us know the situations that we were dealing with here. And we got no answers. I mean, I've sat here for 5 years. This is the first time I've sat before an ACL, and we didn't get any information to look at where there could be any consideration otherwise. And it's very unfortunate that you didn't come prepared to defend or, you know, take a position about your property. There was no evidence or anything to support it, and you left the board in a very difficult position. But as our executive officer said, there is a process. I mean, you could go to the state board if you want to pursue it, but our decision is to do what we need to do today and protect water quality, and wish you had brought in some evidence to support your position, but you did not, and you left us with the choice that we're about to embark upon right now.
And they could go to the Superior Court and seek remedy for if there is impropriety on the ownership of the property. So I have a motion and a second. Roll call.
Ms. Ramirez?
Yes.
Dr. Malcolm?
Aye.
Mr. Schneider? Mr. Bradford?
Yes.
Ms. Brower?
Yes.
Ms. Kadara?
Yes.
Dr. Longley?
Yes.
Motion carries.
Motion carries. Thank you very much. And I think for the prosecution team, I think our message would be, next time you write one of those things, you really didn't allow us the room to move it up. Folks today were very lucky. It could have been a lot more than that. So with that said, I want to thank everybody, though, for your input, for your patience. Thank you. And we will we'll recess until
8:30 tomorrow morning.
8:30 tomorrow morning, bright and early.
Bright and early.